number 1.
Made. My lord, in continuation to the earlier written statement, my lord, I have made a small written statement. In continuation to the earlier.
It happened. Or equity. Thank you. Good. About yes.
My lord, what I want to place to the written statement, my lord, 18.
Yes.
My lord, 18.2 and 18.3 in the next paragraph in page 2, the second paragraph, my lord. If I read it slowly, my lord. That an ejection under Rule 18.3 shall be preceded by a publication of notice requiring the occupant generally to vacate the land. So, notice under Rule 18.3 is for ejection from the land, whereas under Rule 18.2 of the regulation, a man can be or not be ejected forthwith if there is a bona fide claim of the right of the occupant is involved. Therefore, there should be an opportunity given to the occupant to satisfy the authority. There exists a bona fide claim. Therefore, a notice to satisfy bona fide claim under Rule 18.2 and a notice of ejection under Rule 18.3 are two different categories. A notice for ejection under Rule 18.3 will come subsequently if a occupant fails to satisfy bona fide claim or a notice served under Rule 18.2. And my lord, if we read Rule 18.2, there is a provision where it is laid down that, my lord, he may be ejected or ordered to vacate. So, or ordered to vacate itself says that in 18.2 there is a provision for notice. Or ordered to vacate. May I read my slowly? I may be wrong, my lord, but my submission, my lord, is good.
Yes, you are referring to
Rule 18.2, my lord, where it says, if, my lord, the last portion, when further there is no bona fide claim of right involved, he may be ejected or ordered to vacate the land forthwith. So there is a provision, my lord, in 18.2, where it says there may be a notice given that you vacate the land forthwith. And in my written submission, my lord, last two paragraphs I have read down, my lord. If your lordship permits me to read down, my lord. The last paragraph, the petitioner further states the Rule 18.2 states ejectment of a person from government past land or wasteland or estate, which no person acquires right of property, land holder or settlement. When there is no bona fide claim right involved in the occupier over the land, then can only the person be ejected forthwith without any notice. So, from the above language of the regulation, particularly Rule 18.2, it is definite and unambiguous that Rule 18.2 will not be applicable when there is a bona fide claim of the occupier over the land, which needs the ejectment by the revenue authority before ejectment of the occupier from the state land. It is therefore contended that the aforesaid regulation should be read down to mean that it would apply only when there is a bona fide claim of the occupier over the state plot of land. Then, my lord, the last paragraph, that it is further stated that the rights and limitation imposed by the regulation by the concept of proportionality is in a proper criteria. The law should be imposed on the restriction as proportionality.
Mr. Roy Chaudhary, again coming back to Rule 18.2, there are two things. He may be ejected or ordered to vacate. But the authorities may give them some time to vacate.
Sometimes.
There is another aspect.
There is,
but both does not presuppose that there is a notice. An order to vacate, does it presuppose that you would be given an opportunity?
My lord, what I want to place, my lord, the opportunity for bona fide claim and a notice for ejectment, there are two things. My lord, if the legislature has thought it proper that saying that if there is a bona fide claim, 18.2 will not come in. What is a bona fide claim? Well, it has not been discussed for last 1983, where it has said if there is some structure, some crops, some land, even my lord, Section 27 of the Limitation Act, if it is for more than 30 years, he is over a plot of land. My lord, then, my lord, there is some bona fide claim. So, opportunity should be given, at least to say to the authorities that these are the provisions. And if the bona fide claim is refused or is ultimately found by the revenue authority, there is no bona fide claim, then the 18.3 notice will come. Within 15 days, you remove everything and go ahead. So 18.3 will come only after an opportunity given to the occupier that there is no bona fide claim. So then the notice of 18.3 will.
So you mean to say if there is no bona fide claim,
My lord.
then no notice.
No, my lord. If there is no bona fide claim, then 18.3 will come.
Understood.
My.
How will the person know that there is a bona fide claim?
My lord, that is the
revenue authority will know.
Revenue authority will look into and they will formulate a policy and say that these structures for 30, if your person is there for.
So the revenue authority will decide on its own without taking into consideration what the person who is the noticee or who is the proceedee right is.
My lord.
They will decide it on their own.
My lord.
Even prior to asking the proceedee that look here, whether you have a case or not, we are not concerned. We have already decided.
No, my lord. They have to give us the opportunity to place what is our claims on bona fide. My lord. Sorry, my lord.
No, you see, the basic fundamental aspect. How will the revenue authority know that you have a bona fide claim?
My lord. My lord, on a particular plot of land, they found that this is a government house land. And they have gone and found there are some crops over there, some structures over there. And my lord, they will give us the opportunity. Do you have any?
No, a person may be in possession.
Position.
Rightly or wrongly.
Minding.
Whether he has a, otherwise 18.2 does not arise unless there is somebody in occupation.
My lord, definitely.
So how will the authorities know that there is a, that person will may or may not have a bona fide claim?
My lord, that is to be formulated by the government saying that which is the bona fide claim. My lord, in some cases, my lord,
no, whether the government formulates or not, we are at the present structure of 18.2.
My lord,
18.2, does it say, does it envisage out there? How will the revenue authority know? Because one thing you have to take note of, the revenue authority exercises in respect of matters which are barred.
154N.
Not 154, entire 154N. Powers which is akin to the civil court. There the revenue authorities decide, has the power to decide. So under such circumstances, how will the revenue authority know that there is a bona fide claim or there may be a bona fide claim raised or not if they decide by themselves?
Taken for a instance, my lord, I am paying Tojibera though a penalty, my lord, that I am paying for last 30 years, more than 30 years. My lord, now on the asking me if I can place all this receipt for more than last 30 years, so that can itself be a bona fide claim.
But how will they know unless you are put to notice?
So, my lord, that is what my submission is, my lord, that they have to order me that to vacate the land. Then, my lord, I will get the opportunity. Here itself, the legislation.
So, if they ask you to vacate the land, where is your notice to say?
My lord, then I can place my bona fide claim to the authority that this is about the bona fide claim. You cannot eject me now.
That is one, where there is a direction to vacate. What about ejectment? There are two words used. One is ejected or may ask him to vacate.
My lord, because may be ejected only the word may be ejected prior to that, there is after comma, and when further comma, there is no bona fide claim involved, he may be ejected. Then it starts. It starts with from comma, there is no bona fide claim of right involved, he may be ejected. And thereafter, my lord, or order to vacate.
So you mean to say the earlier portion till the comma,
Comma.
further comma,
Then
has to be only on the basis of a notice,
on the basis of a notice,
the first portion. And the second portion, there is no bona fide claim,
my lord,
is only subsequent to the notice.
no bona fide claim. But if they ordered me to vacate also, then I cannot place anything of my document. Neither there is any structure, no prop, no revenue, Toji paying receipt, or anything is there.
Okay. Huh? Yeah. Yes.
My lord, again, what the question comes, what is the bona fide claim? So when we, my lord, we assembled on 16/5/24, I gave a judgment of 1983 to GLR, page 258.
Yes.
My lord, para 13. May I read it slowly, ma'am?
Mm.
In a summary proceeding under Rule 18, the authority is not to adjudicate any complicated question of possessory right or title of the occupant. If it finds that there are paragraph 1(3), madam, 13. 1(3). I'm sorry, my lord.
Yeah.
May I read it again?
Yeah.
In a summary proceeding under Rule 18, the authority is not to adjudicate any complicated question of possessory right or title of the occupant. If it finds that there exists a semblance of claim of bona fide right, it should not proceed under Rule 18(2). While considering the bona fide claim of right, the authority should consider the duration of the occupation of the land by the occupant, the nature of the property on which the encroachment is alleged to have been committed, and whether the claim of the occupant or possession is mala fide or bona fide. When a property is occupied or possessed by a person, the authority competent to take action under Rule 18(2) should not start his eyes to the existing facts revealed from the record. If an occupant openly makes construction, his act might create a bona fide right, title, or interest in the property. The duration of occupation is undoubtedly a relevant factor when the occupation is open and for an appreciable length of time. When some right to occupy in favor of occupant is restricted, it requires an impartial, imperatible adjudication according to the established procedure of law. The length of possession, the nature of the open act of possession, construction of the structures, and dealing the property as his own certainly create a bona fide right in his favor. Such cases should go to the civil court for adjudication of the authority, may take resort to other provision of law or take resort to some other law. My lord, I will not, my lord, vouch on the civil court because there is a bar. But my lord, other authorities of law take resort to some other law. The revenue authority may look into it.
Now, this judgment came in the year 1983. At that point of time, 154A was there because it was brought in 1971. And the division bench then also said that the civil court, if it is a bona fide claim, then the civil court will be there.
My lord, going down my head before the honorable court, my lord, I would say, my lord, there is no discussion of 154N in this. There is no discussion. So if there is no discussion whether, my lord, civil court will interfere after the statute prohibits or it's the revenue authority.
So you mean to say that judgment is per incurium?
My statute does not want me to say such a statement, but my lord, I will say, my lord, there is no discussion of 154. But only there
Now,
is.
if we go by the paragraph 13, categorically mandate that if certain, the revenue authority, rule 18 is a summary proceeding. If it is a summary proceeding, then in that case, once there is an establishment of a bona fide claim, then it says that the civil courts will decide. So it means to say that once there is a bona fide claim, it goes outside the purview of Rule 18.
150, it goes outside the purview of Rule 18.
Of the revenue authority.
Of the revenue.
Once it goes outside the purview of the revenue authority,
then the civil court will.
Then the civil court will decide. It is say, although 154N was there and 154A was there, but 154N and 154A are in respect to exercise of powers under Rule 18.
My lord, I'm your lordship is absolutely.
So if it goes outside the purview of the civil court, of the revenue authority,
then the civil.
then the power which is being exercised now has to be in regard to a power which is a colorable exercise of the power. And if it is a colorable exercise of the power, then it would not come within the ambit of 154N or 154A, more so in view of that judgment of Dhulabhai, 1963, wherein it says that when Section 9 is outstayed, impliedly out here. So that is the only thing if we don't hold this judgment to be per infurium. It has a date. See, as I was saying on the last occasion, me and my brother, bona fide claim would be something where you have a better right to remain in possession. Respect to other. Just for example, in a proceedings on the order 21 rule 97 to 106, a person is dispossessed. He cannot come up with a suit to that effect that I have been dispossessed without following procedure of law.
Correct. And if it is,
He has to show that he has a better right to remain in possession. Taking into the cue from the judgment of the Supreme Court in 2012, 6 SSC, this Maria judgment,
and it's a
there
recent
also
judgment,
it says, if a person is to get a or has a right to remain in possession, he has to show, paragraph 67,
my lord, I have not.
has to show that he has a better right to remain in possession than the state.
Well.
So if that be so, this bona fide claim has to be adjudicated by somebody.
Somebody, my lord. I should not be given, my lord, without any remedy. I should not be without any remedy.
So that has to be decided either by the authority under section under rule 3A of the settlement rules, or there might be an appellate authority which can be either the deputy commissioner or the Assam Board of Revenue, which may be.
Who will decide that?
But that aspect has to be decided if there is a bona fide claim or not. And once it is being held by these authorities, yes, you have a bona fide claim, then it goes outside the scope of Rule 18 and outside the purview of 154N or 154A. That may be the interpretation which one can give for this judge.
My lord, I am obliged. Your lordship is absolute.
I am not correct. I am just yet to hear the ET. I'm just formulating what it is your argument.
Balance is for my faith.
Okay, anything else?
No, my lord.
No. Yes. Hmm. Hmm.
Now, the fourth argument or discussion revolving around the concept of bona fide of the right. that proposing the concept is already existing, but whether that concept can be further exclusively at that because two different actions are envisaged in the two no notice but certain fiction and three is the case as notice and so that is the case already there. But in two whether there can be further application of the document. But before going have a tertiary book and what is book 5. Book 5 application for them. Application for this of them that like that or such other officer as they can cover the other it can such a so when I feel that I take it for but for time. So that really I think I can stop it. Number 2 good settlement of by that all it's so for that have by that for not that not granted by the state government under the court letter for there is another area where the person granted by the government that is beyond the purview of that or property. It is also can. Now coming to that is both that's why the whole factual issue. Procedural to enter in that and to this chat of writing on step on and no person enter. Some of them it is a uncertainty that not otherwise the part by the so that whether any permission is granted or whether any lease is granted to the person to allow him to occupy and remain in possession in a government. These records are available in the popular document. So the no revenue authority, without considering application under 5, application or lease under you have to read 5 and 16 before proceeding to take any action under. But when there is a permission, when there is a lease, 16(3) will apply. When there is no such thing, 16(2) will apply. The legislature are very clear in their mind. It is the intention of the
Mr. Advocate General, are you saying that rule, if a permission or a lease has been granted,
then we can occupy.
then you are saying that rule 18.3 will apply? I have great doubts on that because 18.3 cannot apply unless you said cancel the lease.
Let us, what is 18(3) now before going to 18? In all other cases, what are the all other cases? Because the other cases are the settlement holders, proprietorship, or that. So in all other cases, statements can be treated by publication of the manner right below, equaling the open the notice. These situations, no notice is given. If I do not have a proprietorship right, land holder right, or settlement holder right, no notice is given. If I have a right other than these things, then he will come. Has to be with section 16.
So you mean to say
there are 5 categories of people who are debating in the spot of land belonging to. The 5 categories, the first category is the proprietor. He has to give the proprietor type of government land or a land holder and settlement. If other than it, there's the holder and permission. So for the first 3 categories, if I don't have that object, proprietorship right, settlement holder right or land holder right, I do not have it. Then I am paying a government lot of land. And
Rule 18 does not say anything about leaseholder.
that's why we have seen that both as a not isolated.
You see, if we go to section 6, section 6, regulation 6.
Right, which is acquired over time.
Rights of the proprietor, landholder, and settlement holder, other than landholder, as defined in regulation other than 12. So these are the people who are there. Therefore, you find them correlated with Rule 18.
But we have to, what about that good 16? It's also there.
No, Rule 16 will come into play first if there is a patta being issued.
When there is an application, suppose it is when, or suppose there are a group of or affected by or water erosion or that government may take it off and allow that, but not
Yes, the deputy commissioner can give a permission to stay further.
permission. Or like take the example of Guru when huge group of people they were also they were allowed it there the government permission. That situation that it will be required. We want further remove them from Dolgam because they are allowed to debate there under government permission. We can intend that the government is going to give allotment. Identification is when not from the people. They were allowed some. Or if we take the example of Kajira, when two or three people up because they were the of Kajira. They were alternative management, but about that's not it. But there is permission to suppose government wants to further remove them. That it's our wrong that it cannot be acceptable of us. That is the overall way of function of this. Otherwise, what is the and
Rule 16 says about two things. Lease shall be issued in a written application only. That is Rule 5. See Rule 16. Lease shall be issued on written application only. Yes, yes. If you read,
prohibition to enter that
absolutely. Lease shall be issued on written application, which means the application and file under 5. And no person shall enter into possession
or otherwise a written permit. So till the application is approved by the land and by the government. Temporarily for the time permission by the
what is a lease?
is the
Patta. Now you make an allotment. The government gives an allotment, but the patta has not been issued.
that case also.
Understood. At that point of time, the deputy commissioner permits him to.
It may be allotted the height. If the land, the ownership may not be granted till date of. Lot of public officers are in that manner. So in that case, suppose the government wants to take this by the high court, then they put it. Although the proprietorship or the patta has not been done, allotment is always conditional. So there is a distinction between when it is the category where the permission is given for a deed has been done. That situation that is no. And otherwise, when the person without having history right enters into government debt, the government is not bound to give them.
So you
Now
mean
the
to
one thing-
you mean to say
the one thing is
Rule
always
18(3) only applies in respect of permissions.
lease also. Suppose lease or allotment also. Suppose
No,
allotment is also given and government tomorrow wants to take it back. Because you will not get compensation because the title has not been done. In that case, government wants the land back from for the public purpose. In that case, that's different.
So if a person is in possession
It is-
on the basis of a permission,
Yes.
because once an allotment is given, he does not get a lease. So the lease, after a lease, he has a right. He becomes a landholder, settlement holder, whatever maybe he gets it. But but at the time of allotment, or just for example, in the circumstances like in Kaziranga, you have stated, where the deputy commissioner asks somebody to vacate or have in another place, there is a permission being granted. Then in such circumstances where the deputy commissioner has granted the permission, only then 18(3) will apply, or the government has granted the permission.
Here the deputy commissioner of the policy
60. No, but anyway, the deputy, in view of Rule 1,
the government has been for the power is less than this the deputy commissioner.
now in view of Rule 1, when the government wants, the government can very well direct and the deputy commissioner has to abide.
And the government has delegated the power to the deputy commissioner. In other words, the deputy commissioner.
So shall only apply when person possessing under permission.
This is our way of taking the government intention is very clear because we have the record for having a person for a that record is the difference. Suppose by per looking at in his case, so protect, let us take the his that there suppose the notice is given to let us give as it will be a mere format. Because in our record, that whole area is a business district. No person can be out it. If we have to allot then another give up that another. So in this system, absolutely there is no requirement of public. In that in all this, always the time. The notice is contemplated in the like so why you should not be it. But the statement notice is just the information that he is but
So isn't it the 18(3)? Isn't that a notice contemplated under 18(3)? Because 18(3) says that you will ask them to vacate within 15 days.
Yes.
No, in the case of Kilhaku, is a case where it is a case of water bodies.
here is
And when
easier.
you come to that, water bodies, there is a question of there cannot be anything can be done out there. There cannot be any construction. There cannot be a person who can be in existence out there. So once it is a different thing. Another thing, the Water Bodies Act came later on. That is another issue. We are not into that. But once there is a land which falls within the water bodies, absolutely the state has the right. The question of natural justice and all these things takes an exception.
I pick one more. Here the it is biotech became an allotment of the for this of a buyer part. That's public. More portion of surplus if by a person. How yes, also it's a government person has not a but in this case that what word is here it is one. It is, there is no bona fide claim of right involved. What right he has now? Bona fide claim is one part. Bona fide claim of right involved. What right he has? He has must have some right where he can have a bona fide claim. What right he has now? In our record, is abundant without its epic. That both area is suppose given the notice. Let him prove it, his claim is the bona fide. How can I prove it? I have a office.
Mr. EG, this matter is a single, the single bench will duly consider his aspect as to whether he has a bona fide claim or not. No, but we are concerned about the wasteland. Wasteland.
Now, who is an encroacher? Who is an encroacher of a government fund? Who does not have a land? Who does not have a proprietorship right, and voters right, and settlement voters right, and without any other right, entered in the government, it becomes an does long death of time change the status of the status of man or the day and entered the government without office right. He is the encroacher and the encroacher points for the date of point of view. Right.
What do you say about regulation 6C?
Right expert under section which
That is on the basis of right, no, prescriptive right. That's a right of prescription. That is a right by which a person cannot be thrown away, or he may have some semblance of right. We are not concerned whether he has a right or not. But just adverse possession may be a case 30 years, may be a case as against the state. But the question is, can we allow this only at the wisdom of the SDO? He is the person who has been authorized. It is there in the rules itself, 3C, 3A. So can it be at the wisdom, just on the wisdom area without an adjudication?
has only done in the arbitrary act
Yes.
by our own ticket.
No.
Sir, open.
But can these factual aspects be decided by this court?
Arbitrariness is the answer. There is illegal action in any case, but there is a limit.
Remedy is what? 226 is an extraordinary remedy. That is not a remedy conceived in law. Kindly, no, it is a remedy, Mr.
When all doors are closed,
No,
then
no,
it's
Mr.
so one
Why
close the
should we
bar.
close all the doors to come to the,
Absolutely.
why should we close all that? Why don't you keep
The
a door
answer-
open
No, no,
and
the
say
thing is
that
very
we'll
clear.
close this door, go to.
They are maybe structured. They are a pyramid. Suppose suppose the next thing, where he can all other regulations we have done.
So that I
Government-
think my brother is asking, suppose you go take whatever the
Suppose when
So that you understand. When rule 2,
Yes.
you decide that he has
147.
violated.
One
Now,
forty-seven.
you may be also wrong. Why should he not get
No,
a
no.
chance?
We cannot copy European society.
Yes.
That is object violation. That is object activity. The welfare society, lot of government, not of they are expenditure.
But Mr.
These are all subjective.
Mr. AG, why I'm saying about this thing, you are saying, let's open the gates for them to approach 226. It will amount to a floodgate. Where these factual aspects can very well be decided by your revenue authority itself. It will be a floodgate. Every time they come up with a writ petition, this court taking it, whether there is a bona fide claim or not. If there is some factual adjudication being done by the authorities on the basis of that.
But the step is all that it is for care case. Are there a subject? I must with the first. There are isolated cases coming up.
No, every bench for matter, if you take it up, there are floodgates, means there are so many litigations. And once this division bench come up here and then says that everybody can approach 226, it will amount to a floodgate.
That will not take the law, bigger or the people are active, it always come. There cannot be any bar to them. One 147 is there.
147 will come against what?
The
Orders. Now that order has to be passed by somebody. Here the order is not being passed. Here he comes up and says that, look here, you kindly vacate. Then can you come under 147? No.
He has asked for an order. An order can be also given. A action of the deputy governor vacated here. So their order is the file. Not government does not work that I picked out.
Do you give that order? No,
Order is always there.
Mr. AG, kindly tell me.
Always given to them.
No, do you give the order to them? We are vacating. This is the order. You don't. You ask them a notice. They tell her you kindly vacate.
Yes. Suppose he wants to have the order.
Will you give him so much of time for that?
When a eviction exercise is done, minimum 15 or 7 days given. Cannot go the word approaching government and against public.
Mr. AG, we are concerned about that the lands of the government are being, in fact, this issue not only touches that. While sitting in bench 4 and bench 5, I've seen there are plethora of litigations being filed out there, and every time, 2014-15 matters, when I was taking up that my bench out there, I could find notice has been issued. This court has stated affidavits have not been filed for the last 10 years. The matter has been pending out here, only on the basis. Now, if there is an adjudication,
Case is pending in the court.
you can't do anything.
It is our fault, the government fault.
No, it's not that. Affidavits have not been filed.
Then Lordship, whatever material the petitioner filed on the basis of that Lordship, the will come but what I am saying, 218 has been put to challenge for this several, and it has been upheld.
That's in a PIL. There's no adjudicator in PIL.
Now, where is the challenge here?
No, we don't require a challenge. We don't require a challenge.
We are not saying these rules are bad. Here is a question whether a notice can be read down to Rule 82. That 18.2, that is the issue.
Whether that is permissible in the present proceedings or not. In an appropriate proceeding, definitely Lordship should serve. But in this proceeding, not permissible.
That is the reference.
There's a reference. Reference says whether there are two views. One view says but other not. Lordship may not if this interfere with the rule. very clear. And I am taking our case of where and on top of that, suppose there are two views of two different division or negligence. The notice has one, the other view of another division and contrast. In that case, or that goes to the larger. That is another way of because there is a division bench order, court and bench order. That it is perfect. It's so perfect.
Let's see that.
In that case, not you can now lot before going to the definitely because these are my line of work. Now he has come and enforced. Radha Kanun case very clear 1996 8 I tested for the compilation phase 1.
Yes.
Here the author paragraph 4 216 of the same other described that it can on and no person that answer of the answer or otherwise the person has been granted if when so when a positive have power or on another word types of entity it or they are effect any person who enters otherwise that person it must provide that subject has been answered by the person of that person of a proprietor and settlement. It's very clear taking consideration of now coming to paragraph 5 last point. The government collects on the respect of the person who writes and law is under them for the order of justice. Let the Buddha was that is fine. The incentive to my friends of the at the fine or some different. No other person has got the Mujadar. Not a Mujadar has power to connect the and it not just by the government it contracts the of any other there is but that it's what I said. And the or you the High Court was state error collected by that the for for order. Whoever is there, either of the three types of protected as well as the order, as well as the parties. No can but they have put the complete one. That's it. We have all that.
Do you collect Tozi nowadays? Tozi, the Tozi Moza, do you collect? Does the government still collect it? Because in view of the judgment on Radhakanur, you cannot collect also. The Mozada cannot collect it, as if we go by this judgment.
Now next page is page by the PIL. 7.
But one thing, Advocate General, if we see just above paragraph number 5, the Supreme Court makes it clear that we are not dealing with the rest of the portion of Rule 18.
The procedure, what I am saying, I have tried to emphasize.
Yes.
The procedural part is different. If they have any of the rights under the 5 which prospective that is put as permission. Raise no notice for them. In fact, for the first thing, they will they will be having the with that just give a complaint the 2013 all these acts are regarding complaint. Here it's not a case of grant compensation or case 5.
And in that judgment, very judgment, at paragraph number 7, kindly have a look.
Regard to other order passed by the that case of those factors. What was the situation which they are still up have a permission for the my I is in this case we know that is why if not in all cases we don't issue notice. This is one solitary case where we are not issuing.
No.
In biotech case we are issuing notice.
Mr. Advocate General, we are not going to decide the petition. I'm only the issue.
The government is also applying its mind.
Hmm.
The deputy commissioner not a SDO. It decides which will come under 18, which will come under 82. So it is not a mechanical exercise. There is an application of mind. It's an application. So where?
So therefore, it is something like that you are. Therefore, it is a case that it is within the wisdom of the Deputy Commissioner to issue notice or not.
And the wisdom has to be backed by the record.
So if the Deputy Commissioner or the SDO find, then there is no requirement of records. That's the end of the matter. No, it's okay. For this is okay. I'm not.
It's not an open and shut case. I'm giving two examples.
So therefore,
It's not an open and shut case.
therefore, can we take it as your submission that the Deputy Commissioner or the Circle Officer, as the case may be, would decide as to whether to issue notice or not? There might be a case in Rule 18(2) where notice may be issued, and in a case where Rule 18(2) notice may not be issued. Are we to take it, what you are saying?
What I am saying is
Meaning that notice is not absolutely hard to depend upon each case.
each case.
So therefore, this can be an argument to say that it's not really notice is absolutely hard.
I just keep on getting. Two thousand six, yes. Is one seven. Petitioner of is an 100% there. No, it's not. On the topic of
To the 2006.
360 is 170. Paragraph 170. Petitioner of is an 100% there. Paragraph 36. Therefore, beyond without or the doctrine of proportion can be applied as the case of vision and upon the factor. Instead of the technical review of they will apply their mind. But if some mistake or the model the notice of it, I say some other on the direct tax and every case has under the post factor. It cannot have a blanket application or a promise. The big judgment or private like get the is fine. There is Colonel 7, the prayer. The message they put stated on it put and Roman 4 were ordered during the public of 18 of the Qatar Assam that had added the paragraph 12 and undertaking of the state has been enacted on the by thereby that the voice of the other laws and undertaking of state on the basis of by thereby that as the law is already the other laws but it is and provide under section 1 of the thereof that has the effect of everyone. In other words, the process prior act of eviction also the by so on the one ground that good was held. That is the violation of by but whatever may be the reason, at one occasion, the honorable court appears to declare. So that is the present now. Shakal. Now, Shakal is case. The WP 417 of 2009. Citizen and commercial employee as PKF. Shakal is here all the years laws, good order, and finally, at paragraph 8, may have discussion and conclusion. The argument of the rival counsel the power to reject and protect from government is conferred the all the government conferred by the amendment of the intention of this can be only by those who have acquired right of proprietorship, land holder or assessment holder for such land. Here it is not that the land or none of the are proprietors and therefore both their right their paper
Are you as a rectified G?
All categories of government about the order of Wada as was observed as the eleven. The good 18th of the Assam then forward the have not acquired right of the proprietor and admittedly the petitioners are not the proprietor and therefore both the right for the here for the with that by the claim of right or
and amount we have restored.
not
Yes.
even
Sufficient
the
part.
articles. Well, for eviction of the government
the ratio of
for good property purpose
was
now all like government are but in case
more than identified by the high they think that the company
here somebody
proportion agreed to in the statement
coming period of 40
and therefore have no objection.
here the
The state started
of right for title of the undoubted that our government
has no objection.
There
Proportion of the
the
entire and
have not participated government to participate the mode of
all right.
by the government by those that had back that in our consider
Yes.
and the action of the
Copy of the Madras and over and taken a very good. All right, portion.
yes, moreover we find it that contain enough about the land and
Yes.
aware of it from where they as
Item number 100, already over 130.
that can be made then.
इतना लेवल में कुछ रखने के लिए कुछ लेकर आओ तो
Legal sir.
Advocate General, I'm a bit slow. Just see the judgment you have relied on, Justice Buzurwala. Judgment in that case of all India
This room is open.
Fishermen.
What's in the room? There's just stool like it.
No, not paragraph 13, paragraph
I
10.
don't
Paragraph
understand
10.
this At all. Sir. Why did you issue the check?
Yes. You see, what happened in that case is after the Bandana Gwala
But where
judgment
is the check?
earlier, it was held that there
Then
cannot
it's
be
inside
two
the report.
remedies. One
Where is the check?
a a remedy under the provisions of the civil court, as well as a remedy under the Rule 18.
And where do you say that you did not issue this check in 23?
So under such circumstances, Rule 18 was struck down at that point of time. Then you came up with the amendment by bringing in
Why aren't you
154N
answering the
and
first question?
154A.
Where is the check?
Here the issue involved out here was,
30.
now you have two provisions. The first provision is again Rule 18. You have another provision under the Assam Public Premises Act. And under such circumstances,
What
you
is the
cannot
date on it?
initiate both. This is the ground on which it was challenged. Again,
Why did you
taking
issue
that.
it?
And in paragraph number 10 of this judgment,
Where did you say that in your
division bench
petition?
hold that government lands are outside the purview of public premises. And
I
this
should
very
believe this
aspect of the
only.
matter was also held by the division bench in the case of Muhammad Ishaq.
Guys, now I'm asking you the most pertinent question which you have to
Yes.
answer.
No,
Why
no,
would
no,
you issue
no,
a
no.
check in 23? And
Muhammad
if you
Ishaq
say
is
that
not
it
on
was a
occupied
blank
field.
check and
Earlier
you
was an
filled it up,
occupied
where is
field.
your
Justice
record?
Buzurwar
Where is the
judgment
petition?
was on occupied
That's your
field.
only case here. Then you have no case.
Yes.
I understand all that. So therefore, all you should have said in your petition, it should have been a one-page petition saying the only relevant thing.
OPD ko. হা উঠিব লৈছে নে ব্ৰেক whether it's a break or they are getting up হা হা not very clear অলপ ওলাই আছো ন বেলেগ লোকেশনটো চেঞ্জ কৰি লওঁ
Hello.
শুনিছো ক
আপনার ভিডিও কল ভিডিও কিছু আপলোড করে দিও আমরা মাঝখানে স্পটিফাই আছে কোথাও
Yeah, but
there is another difference that occurs. It that yes, they are the big owners, they are the footprint. The owners are often but they have expert that but the coming paragraph. Here, second one. From above, none of the the concern is higher as forward. Provide the entire of that or that both sides are by that good impairment or as per that 40. If of the change for then here out of the end or about extra I therefore and here also for the other part of the third aspect of the have not allowed by the government to pay. That's the permission. Bonafide exam will go from it. Which is to appear
So have you been able to get out this person out here? This person very much. This case, the petitioner. Have you able? The petitioner, what is his name? Devendra. No, the matter is still pending. Yes, I have asked him to appear in that matter. Remember that matter is still pending. Precisely, therefore, the reason, Mr. Advocate General, kindly understand what my learned brother says is a different thing, but my basic idea. If there is a basic notice is being issued that we are giving you 7 days time to produce all documents as regards any claims, and he duly submits that. And then on the basis of that, an order is being passed factually by the authority concerned. He may file an appeal, that's a different thing. But what happens, there is already an adjudication being done. He may not have any right. Therefore, I was saying about that judgment of Maria judgment, 60 paragraph 67, he has to show a better right. Why he has to be in possession of that, which he has to show. That is the parameter he has to show.
Third right, not that is a different concept of it. The third right, he has to show that the third right is to the government.
Comment that he has the right. That is what he has to show that. Once he shows that he fails to do that, let the authority decide and pass orders and throw him out.
That will be another because it
You-
will give a better door to our officer.
And so that you want to plan everything out here in the High Court
So it's better
and then ask them to file affidavit and the matter is stayed.
different concept. Lot of officers that is so sometimes. In fact, some of the officers have kind of plan. What is the classic case of Amsa? So many people officers have their land there.
Yeah, yes, true.
And that's why I hope that that scope of the matter of Amsa. But that's how the that was the welcome step for us. We did 1,000 members. 1,000 was still there. Finally, again, the new fact. There, because of the petition, they're not big enough. That after the main source of
Because there are authorities who can decide. Why should all these matters come to the High Court? One has to take note of unnecessarily.
Why?
Yes, there might be.
Also,
No, lawyers can very well live in the other places also.
what
You are having everywhere, you are having out there various other proceedings out there. Yes, this court will. You see, proceedings out here, when we take it against the Board of Revenue's order, when we take it against the order, we just look with a lot of circumscription to that effect, that unless there is gross perversity, we don't touch it. Now, if that is being decided by them, unless otherwise here repetitions, there are many repetitions which keeps on filing. That is one very big issue. Yeah.
idea is have somebody here the
Have
number
that.
number where very clear. I can because in the documents are issued by us. When our report is why give that to a bare formality? Therefore, 1820. Done. Why? Why is that of
18.2 and 18.3 was there in the year 1931 when actually these rules came. The rules did not come in 1894, which have been recorded.
whichever year?
At that point of time, you had only 4 types of land. Wasteland and castland were not part of it.
But after
Amendment
went
has
from
made this
from
rule 8 redundant
not with that.
because of the amendment.
Let there be a challenge to that. In an appropriate case, not to definitely look into all this aspect. But here, it broadly says that moving is required in 18.2 also. Can it be rewrite? No. Which is why may not be taken up by the honorable.
No. Where is it? It has been mentioned that 18.2 notice is not required. In which judgment?
Yes. We have to be
No, where in these 3 judgments, where it is mentioned that notice is not required.
there and not the mentioned there. And
Yeah.
that it has to
So we are going to imply.
why we are reporting certain aspects not there. We cannot add something to the
We can also add something into the words of our learned coordinate benches.
I
which is not there.
When the next thing, with the self-contemplated 18.
You see, kindly see here, notice was given. Page 65, notice was given. Encroachment case, similar notices were issued.
Yes, it is ejection notice. The notice which is contemplated, that ejection notice simply says of subject, what is the plot of that, and what have to do. That not, it is not giving him an opportunity to take his claim. There are different. One is just give the information that when the action is done, and in which area the action will be done.
So you mean to say that
And the
in
notice which is contemplated is that, so you're right.
no,
Why you should not be-
no. Kindly see 18.3.
In all other cases, the public. How group to be for how that is the protector or how that are the not as policy that that's why sometimes that surprise element is square.
So,
That
so
seven
this
is
notice,
what not
this notice is under 18.3.
not prohibited, 7 so that means that they will come and protect the both the people are it will come up.
That is your
That
discretion.
our duty because we know that he does not have the document.
It is your discretion to
So when the decision for that notice is required for why that different of the format has whether it's situation. The manner described below. When the I know myself. So, but here some deviance, some affection is so. That is why there time is given for he can clear this wrong. The other situation that deviance is not. Can there be a punishment for different type of murder punishment? So the ability has and it does not have the three types class apartment or the lease entered in the format. All other cases, all other where was allowed to by the land by the government or permitted by the government by the so there is some action, positive action on behalf of the government. It allows him to stay in that particular plot of government. That situation is other cases neither has of the right nor he has been allowed or permitted by the government by the was not like the other sort of visit. It's like a wedding. I buy. There is an and there is a part other at the gate itself, you cannot get back. There is a case of gate back. Another by the petitioner everything of it by the form of like that
There also notice 18.3.
here.
Understood? 18.3.
Section notice
18.3.
and not directly under
No, maybe, but this is actually contemplated in 18.3.
notice say that to establish your bona fide right. That's the different thing. That is not contemplated either in or in.
No, these
That is
notice,
something different.
this case also, it's a notice under 18.3.
Sometimes something that is why they get. So everyone nobody out of job. Now paragraph 13.1. A combined rating of good fire. No person can enter. Consider this as product. Enter of the here it was I thought taking of that are of the purpose of the data as for topic 6.1. It conjoined of the of that happened. The topic of provided in the first then that all of the what by how are the one by paragraph next from of the of when the of the About that construction of the house. They come under by it's not a it's another it's not one more time. It's 30. Paragraph 4. The but part of paragraph 34. Order that I put up for after the it's a policy just but the case of data that is the order and the writer paragraph 40. And order of marked by data as number and it's like here petitioner of so my
You see, rule 18.2, as per you, there is no notice. 18.3 also there is no notice, but you are informed that it's an information. It's actually an intimation, not a notice. A notice in a sense of the notice of property also.
prepare to move them.
So therefore, the rules contemplate that if there is a common land, you are to go out. And if it is a case where if this land falls within the parameters of Rule 18.2, you have to go out immediately. But if it
Now,
falls
notice
within the ambit of
It has fallen for property. It's a government.
therefore,
So when it's a government land, can there be two opinions? It is not a government land. Because the land records are lying with the government. If there is a change of the status of the land, government is the first authority to know. They have to do it. In that situation, why it is required?
so therefore we can take your argument in this manner that the rules do not conceive of any notice at all. If it is a government land and it falls within the categories mentioned in 18.2, you are to be thrown out immediately. But if it falls where in cases of other cases where permissions have been granted in terms of the Rule 16,
Here is the application under 5. And government was contemplating to all the way that the data requirement supporting detailed economic law. But the government earlier may have content that now government has changed it for the whole area has been there. For in that situation, notice is
no, if, just for example, if an application is being given and if it is specifically reserved for specific area, wouldn't it again come under 18.2? 18.2 also contemplates that situation.
proprietor and settlement.
No, down below. You read it.
Any other thing.
No. You have not read 18.2 properly. Read it. What are the cases? There are many cases. Just for example, grazing ground. It also includes those if the government has specifically reserved for a special purpose.
Government that for a purpose. If it is reserved, even if it's not reserved also earlier, prior to the amendment, observe it. But now it is open, including those and other thing or other things. Now it is one. Suppose government is contemplating to give, but when that is give that if that that otherwise is not pending. So partition is given when contemplating the process for granting. Suppose think about Peter along with that. That we not contemplate, but the final outcome has not yet. Government can issue. I mean, the deputy commissioner can give a temporary fund. Ad hoc arrest. And if you think that period, ad hoc government must take of that would not be
We should not add a notice to the provision when legislature has.
till now. If there is a challenge, appropriate for but in this case, but now what that under the law, under the body as it is, what can be done? What is where to be written down? What is at it? It gives some observation of that is, they are not getting that concept of I. So there are two conflicts, but under the existing law as it, but when there will be a challenge,
Our job is to wait people. I also
Correct.
you with
by considering the law and so that the perspective of 2007 and it heard the speed of I two and it is heard. So not right and Barita and another but paragraph 50 on
This is on what point?
some by the
Yes, sir.
the law is stated here and the picture of other. In our opinion, section 31 of the shall then transfer the site. The site. The turn it down before the when the now I in our opinion, it wrote and the restriction for the purpose of the law and the outward empty and it some absurd. However, when the next is and does not the court cannot by different expand or alter the deed of by the cases while the done but that's all that is the object where the language is here the extension of the has gathered from the language. It is a cardinal the concept of itself that when the language of the text and argument the court must affect the word the text and not open the set of the might not, but accept the interpretation as far as the will be it will really be for the diet of the will be the second third mark. In the of care burden of the curtain of or that for their damage there is some or the of the debt service the positive of the their body is yet another of it that is of the case that the board themselves of the box the board have their people used by the and now or and then they have offer they
Now, Mr. AG, this judgment is on the point that if the legislature have put these things in a particular manner, and if it is the language is not unambiguous, don't fiddle with it. Unless if a challenge is also there, if it is
law unconstitutional
then obviously
and there are various things
Yes.
even arbitrariness also. But here there is both. That is why my when it is no challenge, whatever is there as it is not as per the challenge is not appropriate. It is not typically. And on top of that, it is case of it and everything has come out
proportionality.
proportional itself it will yeah better that people can able or
Which judgment you are referring to?
come. Why there are different situations and this is it
Want to say that the rule it says the proportionality is inherent. Because
Inherent,
there are two
inbuilt.
different different
different
situations,
situations.
so therefore two
proportion. Those who have permission or allowance of the government by a government, they have put it for one. That is if it does not have any right whatsoever, the government has not allowed for the day he entered, he has violated the 50. Then to end up by no person there have not prohibit the board is prohibit is barred and prohibited to enter and considered FT and support. And it has been considered by the Honorable Court. Not that I think. Radha Kanu in paragraph 4, last figure. Any person who has to consider otherwise than 16 years and total for so who has violated not followed automatically nothing.
Then if that be so, why there is a procedure given for bona fide claim?
Because there are other title holder and property.
No, that too, that once they come within this landholder, you see, 18.1 says the deputy commissioner's power can only be exercised under 18.2 provided they are not the landholder provider holder.
Right.
Now, if that be so, if we go by Radhakanu's judgment that they are encroachers, you just throw them out. Why the 18.2 conceptualizes the concept of and further has a bona fide claim? How do you read that?
I think the of right involved.
Uh.
And what right involved now.
How do you read that?
I'm just asking myself, what right I have? I am not a proprietor. I'm not a landholder. I don't have a right. In that case, court will be evicted without notice. In all other cases, we have to be conjointly with three. Three says in all other cases, statement itself. Public allow a notice.
There is a word and further.
And
Why
further.
is legislature intention to give and further?
Because Radhakanun categorically says in paragraph number, just before paragraph number 5, the last portion, we are not dealing with the rest of the portion of Rule 18.
Base of the very clear. That is the procedural part.
Why is it then?
What Radhakanu has said. Radhakanu has said an encroacher. Whether from an encroacher we can review fine or not. That is the code Radhakanu. The Radhakanu says clearly as the fact that the encroacher and from cannot take revenue.
In fact, if you see Radhakanun, paragraph number 2, it categorically mentioned what was the question involved. The question involved was, can the Muzadars, by accepting, create a right, thereby that right can be acted against the government?
That is what I think would take that will not act against the government. That has been also clarified.
No, that's the question. That's very
Now,
It's
forget about everything.
it's an encroacher.
I not have any right. I do not have. For what purpose that it is?
No, that is what
Any of the case has come before this
intention of the legislature saying that this person encroacher. Encroacher can be evicted without notice. But later this become also a and further benefit. Let's verify that. Otherwise, we are because there's a great and just plus people. So according to our these are the land and this is your right to have entered into this. You cannot. Now then why that then? So not only that,
Other regulation. What right?
so therefore what should be the bona fide right? Who will decide
That
that?
court is
Who will
we have to take the whole act. What further
The answer can be found in the other division bench judgment which Mr. P.K. Roy Chaudhary has shown. That is also a division bench judgment. 83. Read it.
That's one after that.
No. It does not say anything to that effect. Paragraph 13.
It is a factor.
No.
Actually, I want an argument.
Yes.
What will be your argument?
Fine, I forget it. But that factor, that long of
Which-
Supreme Court said should not have both sides. But so the older judge. That is why all aspects that should pick up. Because there that I have defined the thing but where with the that the Radha case will also be the other division that
Because Radhakanam categorically says we are not dealing with the 18.2 and 18.3.
right.
No doubt about it.
I am at the time I have done, I have not can on a or
That is the permissible. You see, these are the rules. These rules are made under Rule 12, Regulation 12 and 28. Now these rules, the Regulation 6C permits that. How do you take care of Regulation 6C? And not only that, another very pertinent aspect of the matter is these. No, there's no quarrel. No, Mr. Advocate General, there is no quarrel. If it is a VG land, it's a VG land, he has no right. You see, if it is a VG land, he has no right because there is no concept of settlement. But how do you take care of your land policy of 2019, wherein at clause 14.4, you say those people who have been in possession, you will give settlement. How do you take care of that? But you are going to give that. That is your policy.
Therefore, we are not
Suppose no, the case is not. Whether he has submitted an application of the file. As situation goes factor to some evidence. Now I am taking the biotic. Let's take condition from 90. If there on the application has been for the of the those forces are when an application is filed. Lot of things, lot of people, it has that the public say we have to look the other way from both the sides. Nothing has done and all of it that is from the air.
why it right now and murder a bona fide right to why?
Here,
No, no, they are not on this
here
track.
come to the quick. Here, here,
No, no, you forget about this case. How do we look into that? So you say that this is not an appropriate case.
on that ground, there is a challenge.
No, no, not say that. We are saying that rule is as it is good. It says, I these two are the enforcers. We agree with your view. If these are the enforcers, they are entitled for no. But why then and after bona fide claim has come? Let us clarify that.
Without that, without that,
That permission period.
permit with of the
You may allow to enter.
it already has entered allowed to enter, but has not
That will not come for your argument.
it all
Other people, why?
here, but here that's not the that started up. He knows that those kind of or it was never done this. It took their knowledge and exercise. Ask for producing the report.
No, no.
I'm just exercise. Anybody. It's not an abruptly and sudden has been done. After a due diligence.
Okay.
So when the city knows that the permission was given, then they will take decision that is permission given. In that situation, definitely we not have output. When that was not that have come. That is where pilot was although there are thousands of where there is a person, where there is and we are still not there. Large scale find out how the overall method, how the plus, you can all those records support. So now, ideas are there that are still can put much in how there is support from the revenue department that to get huge cost of that in their bottom for a monthly story. Yes,
No, that day I gave a judgment on that. That particular land couldn't have been given like that.
that
But the all said and done, you don't trust your officers.
because of the good officers that they put this good officer. How many monitors we have arrested during the how many land mafias we have arrested? The teams are not a same sort of land that so many instances are coming. And now all the basic officers are time here for our main part. But so if it was some of the persons who are behind bar, only because of both of these stuff. Someone is behind bar. These are also give up. If that stuff, so that is not on the something. every the cricket field also so cleared by but 45 seconds. 1997, 7 and 6. It put
That's paragraph 13.
this one.
Okay.
It's 1990.
Paragraph 1.
Paragraph 30. It's 97, 7. Put okay.
Paragraph 7.
Paragraph, you know, the point is whether if it's forward or for the if the other side not of put up the top of the I up the top of the first top is of in that order to the I have it of our our order what the but I but I there up there the the particular order or only the or suffer or pass the concept of the care for the authority to check the custodian of all the of the eviction act. And if the court says that not about that is not the of my humble submission that is so protected by both ADC that which is it also see from the record. Return that particular that has it what the report also revealed that that is that it but the other is because the court would consider then after the first exam of that is that the action was not perfect. The court also considered that the first of purpose. The court not
So you mean to say he has to record reasons?
is for this. Well, that's why I have
And those reasons will be subject to judicial review. No, obviously, when they challenge an eviction, then those reasons will be subject to judicial review.
the court would also consider the first of purpose. The court not also the first or the top court of the upper court is not it was upper or was there are two procedures. We have to adopt one of the instant case, the case of 500 times. Who was adopted? The case of biotic, who was adopted? The case of harmful care, who was adopted? The case of who was adopted? The case of petitioner, it was adopted. The case of group, it was adopted. Not all cases directly with follow it. There's the application time.
But within the confines of the wisdom of that officer.
Absolutely. But when challenge, in which case, notice have done wrong. At least for last 2 years, there are a huge number of eviction types. There are some eviction types on report of like Ujai in a forest reserve. 200 were up, 400 were living there and running here. So people from Odisha and everywhere went there and Peter on report that and we have done it. Here it. And those have come and have given alternative parents. Now it's promoter basic, yeah, basic the honor. The fuller defect is the lot of format that are and put here regular and here as per as per up to 4. I have for so it are always subject to what there are instances also that that it the field are extraordinary court better court it takes format that does not fall under the now
But isn't the right to shelter a fundamental right? 21. A right to shelter, a fundamental right. 21. So whether that is encroachment or whether it is a case coming within the ambit of a bona fide claim, who is going to decide? The wisdom of the Deputy Commissioner. Because Mr. AG, you say that we take a long, we make various inquiries. What is your problem in having an inquiry and involving these people?
Now it is not that. That's the that would be rewritten. In appropriate cases, logic can data. But proper it makes some observations without observation. Now I have to add, I have to say, if the thing is added now, adjudicating, it's not what I
Your lordship promised me
Hmm.
a small
only
reply.
one. Because one code of code said that one. But I of that.
Unlike the Supreme Court passing the order under 141, whereby an obiter also becomes binding, a judgment of the High Court is only the ratio is binding. That's settled from 1976. Does any of the ratio out here say that there is no notice required? Does any of the three judgments of the division bench say that there is no notice required under Rule 18? It does not. Forget about a single judge. We are not concerned with that. We are concerned with the division bench judgment. Does any of the division bench judgment deal with that?
While interpreting 18, now that court considered whether it is free. If there is a presence of, if there is no presence of notice, so that court was not oblivious of the fact that it is a contempted the notice. While interpreting 18 for 18 one notice, cannot say that the man close their eyes for 18. The language is very clear. That's why my submission. The language does not contempt that. If there is a notice required. So the while the that update or it is as a whole. Self update by the
Supreme Court has gone to the extent of saying that when judgments are written, the words of the judge should not be used as an elusive theorem. You are asking this court where the judge has not even used the words to imply there.
common meaning of the law. Amen will understand of that judgment. That's why I think it out.
For that, we will translate it in Assamese. Don't worry.
I like to read out paragraph of official. Here, place to note that despite the pronoun of the term, there is substantial the number of public bias of the starting with the of the verdict or larger than by size. Minor difference at the number the I have but it does not necessarily but delay the whole. When it is showing something, it has to be along with the judgment. I have concept of the I have that but like
Where is that line? Show me one line. No notice is required.
the judgment has to say that has to be done under 18.2. Now it's where is the requirement of
No,
is the requirement
that is, but where is the division bench saying that there is no requirement of notice? Show me that. That is not there, na?
minor differences or
That is the entire issue.
the best categorical term that exercise undertaken under valid and permissive right system not equality. There is no contemplated there. How can we add notice here now?
In the Brickfield case, in Mohammed Isha case, all cases notices were issued.
That's all this. I do not have reading. I that the best case or
Okay, anything more?
I check that from that the payment is on fund. There, yeah. What type of the outside the
Yes, Mr.
My
Roy.
lord, a small reply to my learned friend. My lord, regulation is the substantive portion and rules are the procedure. Under the your lordship has already said, under regulation 6, if I read it slowly, man, rights which may be acquired by overland. No right of any description shall be deemed to have been or shall be acquired by any person over any land to which this chapter applies, except the following. Except the following. A says about proprietor, landholder, settlement holder, or other than landholder. Then, my lord, as your lordship said, C, right accord under section 26 and 27 of the Indian Limitation Act. Now, my lord, under rule 155, the state government has, for the basis of the regulation, has formulated the rule. My learned friend has said that regulation rule 16 is there. Without a lease, you cannot be allowed to enter a government land. Then you will be encroached, you will be thrown out. On a different situation, my lord, knowing fully well the government allows me continuously, openly, and without doing any harm to me for more than 30 years, is it not an implied lease to me? Then why, my lord, because the regulation itself says that I acquire a right over the land. Under C says, right acquired under section 26 and 27 of the Indian Limitation Act. So, my lord, as an adverse position, my lord, I can claim my right over the land. And now, my lord, if I go to rule 18 again, my lord.
What do you say about those two judgments of the division bench wherein it says that in a suit only the right of adverse possession can be right?
My lord,
Not in, see the judgment of the division bench,
my lord,
which they have referred to in the case of Muhammad Ishaq
Ishaq Ali, page 70 to 20.
or in the other, the Big Clean and all,
My lord,
says that Article 111, I think they have mentioned, is the, they say here,
my lord, while discussing rule
kindly here,
16,
come to paragraph 16 of,
Ishaq Ali's case, my lord.
yeah, Ishaq Ali, Muhammad Ishaq. According to understanding the principle of adverse possession enunciated in
article of liberty can't help the petitioner and the government hasn't filed a suit for eviction. Well, this was a provision where it was only adverse possession can only be held as a defense matter. Nowadays, your lordship is well aware of, as an adverse position, I can file a title suit, claiming my title over that, my lord. So this was the situation of Ishaq Ali when, my lord.
So you mean to say, in view of the constitution, the three judges bench, no? Ravinder Singh Garwal, this proposition no longer holds good.
No longer holds. And, my lord, one thing, my lord, if rule 18, if I place, my lord, if I am a landholder, proprietor holder, or settlement holder, DC cannot throw me out without a notice. A different act is there. There is a provision through which they have to compensation and others there. So they have to throw me in that. In a government wasteland or a caste land, if I am, my lord, or if it is a reserve land or a roadside land, my lord, then, my lord, without a notice, court which you can throw me out. But there is another provision, my lord, last, my lord, and as your lordship said, my lord, and went further, there is no bona fide claim of right involved, he may be ejected. So when there is no bona fide claim, I may be ejected. Then it starts. Or ordered to vacate the land forthwith, or ordered. That itself says that there will be an order for vacating. My lord, after the adjudication of a bona fide claim, then only the order will come. What is the meaning of it? It's clean, my lord. Or ordered to vacate. After an adjudication of a bona fide claim, as regards bona fide claim, under the regulation, well, under the regulation, I acquire the right. Because I have more than 30 years in a plot of land, openly, continuously, without any objection from anybody. 30 years more than, my lord. The regulation itself says that I can acquire the right. And regulation is a substantive provision. Rules of the procedure. Then my only thing is this, my lord, there should be an adjudication for a bona fide claim. And as your lordship already said, my lord, the moment there is a claim of bona fide, my lord, it comes out.
Mr. Roger, if you want to say, we'll hear for 10 minutes on Friday.
Friday, my lord, I'm sorry, I'm not
Okay.
there. my
If you have nothing, then you want to say something? Yeah. Okay, we'll have it for 10 minutes on Friday, and then we'll see it. No, on Friday.
My lord, Friday I will not be there, my lord. I have,
You have already submitted anything more?
my lord, if I am not there, my lord, because Friday, my lord, sorry, my lord, only on if your lordship second half.
Okay, Thursday.
I'm Thursday,
We'll have it 10:15.
Thursday.
The arguments of the piece like here, have been duly completed. So, Mr. P.K. Roy Chaudhary, as well as the learned counsel for the petitioner, and Mr. B.D. Decker, the learned amicus, seeks some more time for giving a reply. Accordingly, list the matter again on 30/5/2024 at 10:15.
Right.
Yes.
A victim on item number 14. That was actually fixed for admission hearing. It is set for the now the matter is pending lordship. The appeal hearing is deferred before the appellate court. Since the matter is pending lordship, appeal hearing is deferred in the before the appellate court.
Okay.
But explained it here. It's possible for
We'll take it. Don't worry.
oblige.
May I please, Lordship? Lordship, I beg to mention RS case number 112, 2016 for listed Lordship. Lordship,
For why? Why do you want it listed?
for hearing.
Not possible. You ask somebody else, go to the registry. Don't mention a matter for hearing.
With the consent of the other side, I beg to mention item number 7. Learned Empress Council has gone to Pune. He's out of prison. So to bring back his daughter. So can we echo the matter?
Mr. Counsel, I'm not going to adjourn a 2012 matter. It's a different thing. The matter may not reach. You may be fortunate enough. I don't adjourn a 2012.
Empress Council is not.
So what? There's always a concept of dismiss for default. We'll adopt that process.
Give us the sort Thursday or Friday, so we will appear for.
Thursday or Friday, there are other matters. Question does not arise. It can't be at your convenience. We will, it may not reach. It may reach. That is, you may ask the rain gods about this. Okay. Yes.
I did.
Yeah.
So that on last of it for this month is what the what for example what the other that has formed to the system holder because of the one prior to it we have five why informant that the system was not now just 91 I don't record 91 subset document what according to that submitted the what is the procedure that they laid down and for how that complied and what is that estimated to the industry as per the instruction my lord from the client what is required there is total officer of the address now one of the team which does respect of address now my lord this is one if it becomes address of they will collect data all the data PCR whatever is there it is which has been done in the present and if the lordship looks into it but not if it here if the lordship looks into the CDR if the CDR is there then the lordship may find that one day 2020 when it was applied from the applied to the before activity for 2 hours to activity a message which is started on one day whether it was or but our not
No. Where is your procedure that you send the message? Where is the additional verification?
kind there are three one step that is put one step
Page.
170 my yesterday five medical
No, I'm not on this. I am asking you, where is your procedure for sending it?
Section 91 one is 91 not one
Yeah.
so that one
No, not this. Where I'm asking you, where is your procedure that you send the message? There must be something guidelines laid down. No, how do I know? Means you see, whether you follow or not, that is another aspect of the matter. But you are mandated to follow a particular procedure is the question. That day, in fact, I put that question out there as to where is your procedure to that effect that when you change it, because that is otherwise not mandated as per the 2016 thing. What is required out there as per the 2016 dot guidelines is the POS at that point of sale, that person will check with the original document and that it will be. But the person who is going to, at the time of activation, it is required that he has to again check with the records which are available with them, which admittedly had not been done. So that is there. Where is your procedure that you have to issue this number?
what is one is one
Hmm.
one is the one is some
Hmm.
I love to try what not done
Hmm.
all the cases customer can what update
No, you have done this maybe now or whatever maybe. I'm not done. Where is your procedure yet you have to do it? No, unless you have these rules. You must be having a set of rules for that.
that topic is what one is the postcard.
No, flowchart is a different thing. Flowchart is a reply to a section 91 note.
Or what kind?
Hmm.
The logical find.
Hmm.
If the logic finds the CDR,
Hmm.
because the CDR will reflect of the investigation, whether the message has been received or not. My lord will guide this, whether it is CDR that message has been received or not by the original SIM card holder. One for a movement and zero input that request for customer on same number customer or have
No, kindly see the number 3 block at page 186. System match the details between system and details entered by the POS of the mismatch pop-up and enter demand pair needs to verify details and need to accept reject as applicable. Then why did you accept and reject when it was there?
Number one, if we are accepted, but now the question here is that whether this body was sent original SIM card. That let us say that that is done.
Why should we look into those issues? Those are for the investigating authority to do that. First and foremost, you are exercising a public function.
That's right.
In that regard, giving public service. Is it your fault because of which now the petitioner had lost? Yes, we will hear you later on. First, let me ask the, yes, the investigating officer, please.
There are other
We will take it out there. Yes, what is your stage of investigation? Yeah, you can just come up. Such is submitted. Okay. Now you have got the numbers, the what do you call the account numbers, which were in which the amounts have been transferred. Now these account numbers were in the name of some company, individual, no? Okay. So did you match it up with the bank details of those accounts? These accounts were in which bank? Canara Bank. Okay. And it was in the name of individuals. All this amount went. How? Okay. Hmm. CSP. Okay. Of SBI. No, of CSP of what? Customer service point of any bank. Okay. Okay. Uh-huh. Okay.
It follows the what retrospect. It goes then here I get the account because it there are also the statement of the there are so let's take a date for the case. They also ask if therefore not
Hmm.
after that after office they take voter ID card. After take voter ID card, even the cattle and it not the moment the ordinance got
Deactivity.
now they have got executed by
How did they get the ATM scene details?
They came, they told that they came from the, and they keep on targeting. So somehow they got cheaper.
Hmm.
Somehow collected.
Okay. Hmm.
So now they have got it will provide 5K for mobile and now the account. So they internet bank.
What?
They open up internet bank. Corporate. Now they have got the department. They the department. But the part, but it transfer money to the bank of and purchase of the is an
Amazon?
open food.
Open pool.
At all, tell the just pay money the person and the money that the person the rest person then takes the person. So what it takes that
Account or these accounts.
now the money is just bank of another bank. If you give the money ATM and transfer from
To somebody else. Okay. So the money went to these people, but this 20% went to some other person.
Yes.
And how is Quicksilver involved?
they told that Amazon no Christopher did
Quicksilver means which company? Hmm. Okay. And is this this is a very high level investigation required for this?
Yes.
Who is investigating this aspect of the matter? You are only. And how? What is the what are the help you are getting from any other source for the purpose of it? Hmm. Hmm. Yeah, it's okay. Are you getting any help from the CID out here? Because here is a case where I think the you have a particular technical technical team in the Assam police who does this type of, these are very technical things. So are they helping you out in this investment? Because if this is not done properly, it may lead to the your investigation. There might be a lot of loopholes remaining in the investigation, and the accused will go out. So do you need a very technical team for that? Yes, madam. What are you doing with this? This is a very high level investigation. How is he going to cope up? You have no the technical knowledge about this. Do you have? So therefore, do you require special experts for that to find out how this has happened? So don't you think that I think the CID has a branch for that, these electronic frauds? Who does it? The cyber crimes? You have a cybercrime branch? Are they doing anything out there in this particular case? Not yet. Because unless you bring in, it will be very difficult to trace out. So they took the account number, the details of the debit card as well as also the PIN, and thereafter they went to the CSP of the particular bank, got the mobile number he was in whose name, and called up him and got the mobile number in whose name, whole address, and then they made a fake ID, and this must have happened. This must have been done within a very short span of time, because of the fact that the amount was just credited of 9 lakhs or something was credited only very recently. It didn't happen much after, because earlier he didn't have so much of money. No, that is okay. What I'm saying is, he got this amount credited. When did you get this 9 lakhs credited in your account?
Just
April 2019.
yes. Page
17th
24.
April
Page
2019.
24.
Huh?
Page 24. And 25. 25 page. Page 25. That was 10,67,000 was, oh, sorry, 9,67,000 of provisional DCRG was paid.
So this money was there, so he came to know about it.
These amounts were credited, and this was done much later, after 6.
This happened only more than 1 year after.
9. No, it was yes. 6 months. 1 year. He was taking out money regularly from this account.
Okay, thank you. Thank you. Do you have a copy of your charge sheet?
Yes.
Can you give it to her? Just I'll have a look at it. But your charge sheet is bereft of details which you stated. Why these are not there in your charge sheet? It seems not to be properly done. No, if that is so, I don't you think that these needs to be brought on, because charge sheet we have to explain what are how the offense was done. Doesn't seem so. During investigation found sufficient evidence against them to be established, hence I submit the search. Better finish. So charge sheet is something like a complaint made by the police after investigation. That these are the things how we investigated, how we found out so and so, and this is a things which is there. And on the basis it can be framed. Do you have an additional copy? This is the one only. Yes, yes. Yes, the bank official who was there. Yeah, we have asked you to come for one purpose, nothing otherwise, for us to get a good know as to how this can be perpetuated in this, how this illegality could have been perpetuated, to get a grasp of the situation. Now you have seen out here that here the debit card details were taken. Then somehow they obtained the PIN. They went to the CSP, got the mobile number. After getting the mobile number, they called up saying all these some fake things which stated, got the details as regards whose mobile number it is. Then they obtained the mobile number, they got it. Now, if you have seen the bank statement, the payments have been shown to have been made to some Quicksilver Solutions. Whereas the investigating officer says the money has gone to the bank account of that. On the other hand, how is it possible? Can you put somebody else's name in the beneficiary name for getting the amount, although that is not actually the account? Have you seen the bank account statement? It doesn't show. It shows that this money has gone to some Quicksilver Solutions. How is it possible? Can you, just for example, you may have anybody's name. Can you put it as the beneficiary's name in respect to a particular account?
Payment gateway. They transferred the that bank. From there they have transferred.
Quicksilver is an app.
Maybe out of not out of our state, not but lot of fake apps maybe like that. They are not there. From there, somehow they have other banks.
So they may have opened up some account in the name of Quicksilver also. Because otherwise, if we remember, if you know, Quicksilver, if I not know, if I'm not wrong, has something to do with these internet antivirus system, or do they do anything with the antivirus? So, gift card.
I was not here, but there is some dark space. That darkness is just there, but producer picks up the app like that dark. From they from that darkness, there is some type of quick type of app. That's not there. But there nobody can access that dark.
Okay.
The darknet only they have only like there may be or expertise in cyber cyber from there only they have first part there is the darknet. There they have so the idea part that by the customer or if not, they can get my IDN, IDA path, PDF, but that get their IDA path, PDF, or further part.
So what they do, they purchase it through another mode by another third party. They purchase it through the gift card, and then they transfer that gift card to those persons. This is what it must have happened. And the person must have kept 20%. Whose affidavit is this? Where at page 84, additional affidavit filed by respondent number 9. That's yours affidavit, no? Respondent number 9 on behalf of the respondent number 6 to 8, 6 to 9. Yeah. What you have enclosed out here, these documents at page 85. Page 85. Your additional affidavit filed on 20th of November 2023.
If I got the message, but registered by now.
Huh? This is a statement.
Fine.
Right. Now you come to page 120, running page 119. This is the RBI circular. Here. 6162. 61 says, 6 says about zero liability say arise where the unauthorized transaction occurs in the following contributory fault: negligence, deficiency on the part of a man; third party breach where the deficiency lies neither the bank nor with the customer but lies elsewhere in the system, and the customer notifies the bank within 3 working days of receiving the communication from the bank regarding the unauthorized transaction. Now, kindly come to page 120. Maximum liability of the customer under 7 Roman 2. Now, amongst many prepaid payment instruments and gift cards,
until it the that he the bank member for 9 after 3 weeks. So yeah, kind of he kind of compromise kind of he and the
OTP he did not. OTP he did not. OTP was because of them. OTP was because of them. There's no question of him be compromised. Now, as of the investigation which have been carried out till now, it only could find out that this person was hoodwinked to get the ATM details. It is not that he shared the ATM. He's only, as per the police thing, he only stated to the effect that they made a call and asked him whose mobile number it is, and it has been stated that the mobile number belongs to so and so. That is what the police could investigate. The charge sheet doesn't say anything to that effect. So under such circumstances, the bank has not fault. Understood? Just for example, let us assume that it has not been the fault of the bank, him or anybody. But if it is reported within 3 days, this is a pure and simple case where that particular person's thing has already been defrauded, not because of that he shared anything to that effect. He was taken up and he was hoodwinked out there to get the ATM details, and the PIN also somehow they got it somehow. I don't know how they got the PIN number. CSP, they went out there and got all this information, and under such circumstances, the fact that he would come under 7 Roman 2. Now the question it is, one thing is that we also have to take note of that this is a bigger issue which this court will deal with it as to whether the liability would be there of the Airtel or anything can be given to you. This court will decide. But one thing this court and the interim measure would like to do is direct the state bank to make the payment, which shall be, however, subject to further decision of this court as to whether this court will direct you to recover it from them or not. That is another issue which we will decide later on. But on the basis of 7.2, and if it is as a case of a normal businessman or any other person, I would not have said anything. But here one has to take note of that he is an aged person, he is a senior citizen. Secondly, he is also a case of, he have never used any internet banking earlier. He never used anything to that effect. And it is his pension amount which is the amount which have been taken for debt. So the fact that he is entitled to the amount, there is no quarrel with that. But the question is whether you would be entitled to recover from them. Huh? You can very well recover. I'm not disposing of the matter. You see, further, now I have to involve the crime branch. Because not the crime, what do you call that? Cyber branch. Because without cyber branch, the charge sheet which he has filed is gone. Is of no use. So there is to be something done out here because this is a very big issue, which is up this SIM swapping and all. This is a much bigger issue than what it is seen out there. So under such circumstances, this issue will be decided. That is why I got an affidavit from the DOT also, wherein it says that there has been no compliance by the Airtel in certain aspects. The reason why I brought in the DOT is basically your lawyer would say that the only reason is, can we direct the Airtel to the SBI to move the try, or can this court decide, or can I refer this matter to try so that you can get that amount? Because if it is a case of, because this would be the first of the kind in the country where in the case of a SIM swapping, the bank is otherwise obligated as per the Reserve Bank to make the payment. Let us take an example of 3 days. You would be obligated to pay. But it may not be your fault. The fault may have been on the basis of the operator. So this aspect has not been dealt with by any judicial decisions as to what is the recourse to be given to the banks for that purpose. It may be a case where the bank may be asked to either recover it by any other means, or can you go to the try and do it? Taking into account that the DOT categorically says that there was a mistake. So therefore, first, this court also needs to take note of that keeping this matter pending for the petitioner to get the matter, because the Airtel has brought up many other issues as to what CDR and what not and all these things they have brought in. So these are the facts which can be done with, not with the normal police officer. It can be only done with the help of the the cyber branch, who are more technical into this. They can very well find out with the CDA and all. We'll decide that aspect of the matter later on. But first, he should get his money, whatever has been transferred to that. That is it. That, however, that payment has been made. Whether you are entitled to recover from them would be decided further in this litigation. Absolutely. No, not today. That would be a long drawn process. Mr. Counsel, you understand this. For me to direct, I can direct Airtel to pay compensation to you. There is another, this is a long drawn process. But can I keep this person who have already suffered for 4 years? One has to understand this. He has suffered for 4 years. A litigation has been going on for the first 4 years. He is a pensioner. He has his all hard-earned money. The final deposit which he have got on 17/4/2019. That money which he had in his bank account has already been taken away. It is no fault of him. Yes, it may be a fact that he may not know the nuances by which how the tricksters are. I may tell you one thing. That day, a judge like me gets a call from a person stating that he is from FedEx. He says to me, I put an FIR to that effect. He says to me that some parcel you send it from Bombay to Taiwan have been held up. And under such circumstances, you kindly report to the cybercrime out there, we will tackle with it. It's a different thing. I inform them. And this is not me. Many other people have got it. For me, I can have the resources of the police. I can very well ask the police to do it. But you have to understand what will happen to a common man. This is the sort of cybercrime which is being going on. So here is a case where the petitioner requires to be paid his amount at the interim. Rest we are considering what is to be given to State Bank and what avenues are there. Because I also am concerned because it is the State Bank is not the money of any other purpose, it's the public money. So what can be made out there if there is a fault of SIM swapping? In respect of SIM swapping, there is normally no cases out which I could find out where the courts have passed any directions. Normally, you find out everybody is following these RBI guidelines and matter is ends. This is a specific case where it has been on the basis of that affidavit of the dot, it is clear now that there is a fault of the Airtel. Yeah. Huh? Understood. Whether it is there or not, the fact that whether there was a fault, one thing is very clear, that it is not the fault of the petition. Matter ends there. It is a fault of Airtel. It may be a fault of Airtel. How much it is a fault of Airtel, that is another aspect of the matter. But the fact that it is not the fault of the petitioner, you can deduct 10,000 rupees against each transaction, it's a different thing. That is against each transaction. Na? The transaction liability of the customer shall be limited to the transaction value of so and so. 10,000 against each transaction. Page 119.
Here it says per transaction.
Huh?
Here it says per transaction liability of the customer.
10,000.
That is shall be limited to the transaction value of the amount in table 1. Here it will be table 1 because the amount is much.
So against
Will
each
be
transaction, there will be a
10,000.
deduction of
There
10,000.
are about 9 or 10 transactions, so about 90,000. I think.
So that would have to be deducted by them.
That have to be
Now, as
deducted.
to how much amount they will be entitled from the State Bank, they will consider later on.
And then there is the other part.
Yes. ATM, no.
No, no, ATM.
Here's the so here's the problem. If it is poor, if the but it is
Mr. Counsel, let me tell you one. The fact that they have got the PIN, there is no quarrel. They got the PIN somehow. PIN has they have already received. Now, once you have the mobile number with you, you enter into any UPI transaction, Google Pay, UPI, Phone Pay, everywhere. You just put your phone number out there. Automatically, whichever the bank accounts are there, tagged with that account, automatically appears. Once it appears out there, you put your PIN. Matter over. That's the simple thing, you do it. Today you use Phone Pay, Google Pay. What do you use? Phone Pay. You delete the Phone Pay. Put your phone number then and see. The moment you put all your bank accounts which is tagged with that will come in, and then you tag in, then a SIM where the SMS will go from there. It will be approved from there, and then you have your UPI address. Matter ends. It's a simple thing. That I can also say, being nothing, not knowing much into technicalities.
UPI address is also just the name with the bank at the rate of.
No.
Mostly
That
that-
is no. That is again different. You can have the UPI address different, but you see there is a difference out there. If you put the bank UPI is another thing.
Oh.
If you have, just for example, you have ICICI Bank, Yusuf Manan at the rate of ICICI. Okay.
That is there.
No, there's no problem with that. But for that, you have to open the iMobile, and in the iMobile, you have to open that, and then you have to put your PIN, the ATM PIN there. So there it's a different thing. But in the case of Google Pay and all these things, you don't require that you choose your PIN there. Only thing required is that you have to have the SIM card. And why they initially went for this UPI thing, because UPI is lesser amount. You cannot
5,000.
have more
I
than
think
that.
it's a 5,000.
And therefore, the more amount will be later on taken up once it is, you can do through internet. Yeah. So thereafter it got closed. You cannot do it. They have a limit also. State Bank has a limit how much you can do every day UPI, isn't it?
I think it is 50,000. It is
got to guide.
Understood. Therefore, I'm saying about UPI, if you do it, you have a limit in a day. You cannot go transact more than a particular amount. But if you are doing it by INB, the internet banking, you can do it.
because initially first payment from a UPI, I think cannot go. I think beyond the limit of some very small amount. First UPI transaction in anything. If
Now,
you
therefore,
cannot-
they did the 5,000 one.
So initially they did 5,000, then they went for 50. That to next.
Now, how did the ATM withdrawal happen? On 20,000? On third? You withdrew it.
No, third it is not.
Now, how did the ATM withdrawal happen? If you had the PIN card with you.
That because this part on third no withdrawal was. Yes, only the withdrawal was the 9,500 on second.
Now, how can this? That means you lost your ATM card.
There is nothing with regard to loss of ATM.
Then how is it possible that an ATM withdrawal has happened?
This is what.
No, 20,000. Yeah, that is what on third. You did not lose the ATM card.
Hmm.
So how did this transaction happen?
This ATM cash is some number is shown 85968 SBI. A learned friend can enlighten us on that. What is that number?
Cash withdrawal.
This is ATM cash withdrawal.
What is this number 85963?
Every time there is some reference number.
From where it has been withdrawn? You can get from that. Yes.
No, that is another way by which you do it. You have your Pay out there. You Pay, you go for this amount and you don't have to put anything. You can get it by putting the PIN there.
So that's the ATM ID that we can locate that ATM.
He has withdrawn
Yes.
on third.
Now, how
So
did
it
you
has
say
been
that?
checked. It has-
I understand, but whether this number says,
Yeah, it is ATM number is there.
Mhm.
We can look at that ATM number. from
yes,
where it
that's
will
what
be
I'm
generated.
asking.
Without
Then the PIN will be there. ATM will have a PIN. That is the debit card PIN.
debit card.
He will have the PIN because he has an ATM card. So there cannot be a withdrawal by anybody else. This 20,000. Understood. But then how can there be an ATM withdrawal without a card? No, somebody has
He
called.
said somebody called and took the address and the whether the phone number is in whose name. These two things that has been discussed. Because PIN was taken on the very first beginning itself. The PIN somehow he said by either somebody sitting behind and taking a photograph. It could have been maybe whatever it is. The PIN was that how the PIN had the prosperous take.
No, the
The withdrawal
20,000
part also
could
I'm
not have been
very sure
withdrawn.
how it has been. He has not been.
No, how can that, without the ATM?
card, it cannot be. There cannot be.
So then,
If it is on the second, then it is fine, but not second. It was on the third. And from the records, I find
hmm?
no, that is by the petitioner. It is already there. That is already he has stated in his FIR that I have withdrawn 9,500. Thereafter, I could not withdraw.
Now kindly see another thing, Mr. 310, there are two transactions by UPI. Earlier, the transactions were Quicksilver. Now, this goes to some at 01171 Romia. If you see on 310, there are two transactions of 50,000.
what it is. So it is type it is
ये उसका मतलब इसका they have done it previously but got huh? ये रिवर्ट नहीं हुआ ना
correct that there is no interruption for there.
हाँ ये 210 का भी 5,000 वही है no, that he has done it
9,500 was done at 2 p.m. Sorry, 2:46:56. In that report, DLR report, they have attached this ATM transaction was done. Delivery status is shown as failed, and this was down from SBI ATM. Your lordship will kindly take up that. Then the next ATM transaction was shown, your lordship, in the next page. SBI ATM that was 1631, same date, 1529. This is delivered. Here it is shown as Yono cash withdrawal. ATM so and so.
where
The next, that page your lordship has taken now, where from they have shown the status. Then the next page, 1, 2, 3, 4, 5, 6. ATM SBI, which was on the 3rd. You said your lordship, they say that it was on the 3rd. This was 1529, it was done. And message was delivered. And something in the remarks column, I think, column is it? SMS content. It is shown as Yono cash. Rupees 20,000 withdrawal at SBI ATM Swin.
no page running page
Page 50. Page 8.
huh?
Running page. This one, in the first page, your lordship will find the ATM withdrawal, 9,500 from SBI ATM, so and so is the bench book.
Where
That is first paper, page 66.
page 65
SMS DLR report from 2nd to 4th. Heading.
page
Then your lordship will find 1, 2, 3, 4, 5, 6, 7, 8, 9.
9,000 bar plus
Okay,
service
10.
plus action
10 number is 9,500. I have withdrawn.
Hmm.
Admitted. Now your lordship will go to the next page. 1, 2, 3, 4, 5, 6, 7. ATM SBI. This was on 3rd at 1529. It is shown as delivered, but in the SMS part, here it is shown as Yono cash. How it has been done?
So Mr. This is Yono cash. Yono cash happens like this is actually shown as ATM withdrawal, but it is not. Without the debit card, you can do it.
Yes.
Yeah, this they have done it. Huh? Debit. So that is why this happened. This is Yono cash. So without that, you can do it.
Anyway.
Let me dictate. Heard Mr. Y.S. Manan, the learned counsel appearing. Yes. Page 50? 58 is not there. Uh-huh. Hmm. Yes. Hmm. Hmm. Laho. Okay. Let me dictate. Okay, I'm coming back in time. Yes.
Entire my lord, SBI bar circle had been each and every my lord put an 100 they are my lord they lord the branch here is 100 whatever each and every my lord how can they
Then let the bank take it up with the Reserve Bank.
and to have up for us the successful transaction of the customer with sales it are occasionally they
Okay, I've heard you. Let me pass the order. Mr. Counsel, I've heard you. Rest, if you have to say it before the division bench. Heard Mr. Y.S. Manan, the learned counsel appearing on behalf of the petitioner. Mr. Your name? Kedas appearing on behalf of the respondent numbers 8 and 9. 8 and 9. I also heard Mr. Kedas, the learned counsel senior counsel appearing on behalf of the respondent number 10 and 11. Ms. Udas, the additional senior government advocate appearing on behalf of the state of Assam. And who is appearing for the union? PKS Burua. Where is he? And Mr. My party Bonafide, you have not filed your, have you filed that yet? Amended post title you have filed, huh?
I have filed it. He has also filed his affidavit.
CKS Bulwa appearing on behalf of the. This is the case where in addition to that, this court have also heard, Mr. Your name? GK? GK Singh. What is your designation? Chief Manager of? Chief Manager, Rongia Branch. And the investigating officer of Rongia Police Station case number 944 oblique 2010-20 is also present in the court. The petitioner herein is a senior citizen who would be presently 66 years old. He retired as an assistant teacher in the year 2019, and on 17/4/2019,
Got it. Just one correction. He retired on 1/4/2018.
that's okay. He retired in the year 2018, and on 17/4/2019, his pensionary benefits amounting to rupees 10,67,600 was deposited to his bank account bearing number 109,582,25308, maintained in the State Bank of India, Rongia branch. Admittedly, the petitioner herein gave the mobile number to the State Bank of India, which belonged to his daughter, one Tulika Deka. On 9/10/2020, when the petitioner went to withdraw an amount of rupees 5,000 from his bank account, he was surprised to learn that the said bank account had only rupees 69.61 paisa. Immediately thereupon, on 9/10/2020 itself, an FIR was lodged before the Rongia police station. Which was registered as Rongia PS case number 944/2020 under section 420/379 of the Indian Penal Code, and subsequently sections 120B/419/468/471 of the Indian Penal Code, read with section 66C/66D of the Information Technology Act 2000 were added. When did you inform the police, them? The, the State Bank?
No, State Bank, same day, State Bank directed me to approach 9/10 itself. I went to the State Bank and they said that
On
you.
9th, on the same date, the State Bank, the manager, whom did you inform?
To the chief manager Rongia Branch,
On the
Where's-
same day,
who has issued the letter on 12/10, receipt of my account. Page 44 is the receipt of.
on the same date, the chief manager of the Rongia branch of the State Bank of India was informed that an amount of rupees 8,95,024 have been fraudulently withdrawn from his account. Which aspect of the matter was duly acknowledged by the chief manager Rongia branch by the communication dated 12/10/2020, stating inter alia that processing is being carried out as per the SOP. It is further seen that on the basis of the investigation so carried out by the Rongia police station, various persons were arrested for on the ground that the transaction in question, on the ground that it was not the fault of the petitioner, which led to that illegal and fraudulent transaction. And the petitioner having duly informed the SBI, the State Bank of India, on 9/10/2020, that is within a period of 7 days, working days, 7 working days, and the State Bank of India having not refunded the said amount or not reimbursed the said amount, in terms with the circular issued by the Reserve Bank of India dated 6th of July 2017, the instant writ petition was filed seeking a direction upon the respondents to recover the amount of rupees 8,95,040, which was fraudulently transferred from the petitioner's bank account, and to pay the said amount to the petitioner. Or direct the State Bank of India to immediately compensate the petitioner by making payment of the said amount of rupees 8,95,040 along with adequate interest. Semicolon. Direct the service provider, that is the respondent number 10 and 11, to adequately compensate the petitioner for commitment of fraudulent disputed transactions online through their service, as well as also for a direction that the investigation should be carried out either by the state CID or by the CBI. This court finds it relevant to take note of that Annexure 10 to the writ petition is the statement of account of the petitioner in respect to the petitioner's bank account. The petitioner duly admits that on 2/10/2020, the petitioner had withdrawn rupees 5,000, 9,500 from the ATM. However, the remaining transactions thereafter from 2/10/2020 to 4/10/2020 were not carried out by the petitioner. From the said transactions, it reveals they are not carried out by the petitioner, except an amount of rupees 17,966, which was transferred to the SBI life insurance on the basis of what is that term called, which is automatically deducted from the account by the insurance company or bank? What is that? Is the term used?
Auto debit.
On the basis of auto debit. It has also been stated by the petitioner that the petitioner neither have at any point of time applied for internet banking, nor had UPI transaction, nor had you carried out any UPI transaction. Pursuant to the filing of the instant writ petition, the Superintendent of Police that is the respondent number 3, had filed an affidavit in opposition, stating inter alia as to how the investigation had carried out, was being carried out. And it was mentioned that the money which was taken from the petitioner's transacted through the petitioner's account were transferred to two numbers of accounts, being 203-6680-7543 and 1131-010-21957, which belong to one Soed Ahmed Loskor and Rasid Ahmed Borbhuya. The State Bank of India filed an affidavit in opposition on 22nd of April 2021. Stating inter alia that the internet banking facility in SBI can be activated through user self-driven procedure by using ATM card details without submitting any physical application at the branch. It was mentioned that the registration process is available in the SBI internet banking site. It was further mentioned that there was no deficiency and laxity on the part of the state of the officials of the State Bank of India. It was stated that on 3/10/2020 and 4/10/2020, various transactions were done in the petitioner's account through internet bank and the UPI, resulting to decrease the balance to rupees 69.61. Further, it was stated that the 9 numbers of internet banking transactions were carried out with the help of a secure OTP, which was successfully delivered to the petitioner's registered mobile number, being 99544-64365. In paragraph number 7, the SBI authorities duly acknowledge that the petitioner's internet banking credentials were compromised as a result of the 9 numbers of fraudulent transactions which had taken place. It was further mentioned that all the frauds were merchant-based transactions where the funds were remitted to a merchant, inverted comma, Quicksilver Solutions, inverted comma, close, a third-party transaction, and there were 3 unauthorized UPI transactions of an amount of rupees 5,000, 50,000 and 50,000 on between 2/10/2020 to 3/10/2020. It was mentioned that the petitioner had compromised his secret UPI PIN to the fraudsters. OTP is not required in UPI transactions, but only the secret PIN is required to log in to the UPI application. To the said affidavit, the statement of account of the petitioner was enclosed for the period from 2/10/2020 to 5/10/2020. In addition to that, the SMS DLR report from 2/10/2020 to 4/10/2020 have been enclosed as Annexure B. This document is essential, taking into account the stand which was taken by the respondent State Bank during the course of the hearing. Inasmuch as Mr. Kedas, the learned counsel for the SBI, submitted that the OTP for payment of the SBI Life was issued, and without the OTP, the SBI could not have, Life could not have auto-debited the said amount. And on the basis of that, have tried to justify the stand by showing the SMS DLR report. However, at serial number 5, which is the delivery status of the OTP, it shows that the said SMS failed. In addition to that, another very interesting aspect of the matter, which was submitted during the course of the hearing, that there was an ATM transaction being carried out. ATM transaction being carried out of an amount of rupees 20,000 on 3/10/2020. And therefore submitted that if the petitioner did not have the and therefore submitted that the said amount of 20,000 could not have been withdrawn by way of ATM withdrawal without the debit card. However, interestingly, it is seen from this very SMS DLR report that the said amount have been withdrawn from the ATM as cash. This court, during the course of the hearing, had asked the chief manager, Rongia, who was present, as to how the cash is generated. And for that purpose, whether the ATM card is at all required. It was submitted that the cash is generated on the basis of a application. And in the said application, after carrying out the required, after incorporating the necessary details, a particular OTP is given, and on the basis of that OTP, the said amount can be withdrawn from any of the SBI ATMs. This court further finds it relevant to take note of an affidavit filed by the respondent number 10 and 11, raising the maintainability of the writ petition on the ground that the writ petition was not maintainable against the respondent number 10 and 11 as they were private, as they were not a state, or they do not come, they are neither a state nor other authorities. This court, taking into account that the respondent number 10 and 11, while providing service to the public, exercises public functions, is of the opinion that the writ would be definitely maintainable against them. The State Bank of India further filed an additional affidavit pursuant to an order being passed by this court. On 16/11/2023. In the said additional affidavit, which was filed on 20/11/2023, it was mentioned as to how an internet banking, it was explained as to how the internet banking can be, facility of internet banking can be activated without branch visit, as per the circular of the State Bank of India dated 28/4/2015. In addition to that, the respondent, State Bank of India, have also produced the internet banking activation details of the petitioner as enclosure D. From a perusal of the said document, it reveals that the username so assigned to the petitioner's bank account was one Tulika Deka, all small, 22. And the entire transactions were carried out on 3rd and 4th of October 2020, leaving aside an amount of rupees 5,000, which was done on 2nd of October 2020. The record further reveals that on 21/11/2023, the respondent number 10 and 11 filed an affidavit in opposition. The said affidavit in opposition brings on record various documents which are very pertinent for the instant dispute. The said documents have been collectively enclosed as Annexure A series. The first document is the enrollment form of the daughter of the petitioner, wherein the address was duly mentioned at village Murara, na?
Yes.
Murara P.O. Rongia. Technically encloses Annexure A series. And the date of birth was mentioned as 11/4/1990. Along with the said application form, the identification document was an identity card issued by the Rongia Higher Secondary School. And an electricity bill issued by the Judicial authority. It is also seen that another person, person impersonating the daughter of the petitioner submitted an application on 1/10/2020 at 15:41 hours for SIM swap. The date of birth of the third person was mentioned as 1/1/1985. And from the perusal of the said application, it seemed that the said application was submitted at Guwahati. Along with the said application, an Election Commission of India photo identity card was submitted. Wherein the address mentioned is village Hiragota, PS Rongia. Subsequent day too, on 4/10/2020 at 10:52 hours, an application was filed by the original daughter of the petitioner. Stating that the SIM and this was duly received by the point of sale agent of the respondent number 10 on 4/10/2020 at 10:52 hours. Along with that, an electoral ID photo identity card was submitted of the daughter of the petitioner. Wherein the address was mentioned as village Murara, PS Rongia, subdivision Kamrup. Pursuant to the affidavit so filed by the respondent number 6 to 9 and next 6 to 9 and respondent numbers 10 and 11, the petitioner filed 2 affidavits in replies. In reply to the affidavit filed by the respondent number 6 to 9, the petitioner enclosed the certificate, enclosed the circular issued by the Reserve Bank of India dated 6/7/2017. Wherein at clauses 6 and 7, six, 7, and 8 have been referred to. Taking into account its relevance for the purpose of the present order to be passed, the clauses 6, 7, and 8 are reproduced here in under page 119 of 121. In clause 12 of the said Reserve Bank circular, It was categorically mentioned that the burden of proving the customer's liability in case of unauthorized electronic banking transactions shall lie on the bank. As regards the reply which was filed against the affidavit in opposition filed by the respondent number 10 and 11, the petitioner reiterated its stand which have been stated in the writ petition and denying to those statements and allegations which were contrary to the contents of the writ petition. And further, enclosed a circular of the Government of India, Ministry of Communications, Department of Telecommunications, dated 1/8/2016. Clauses Roman 2 and Roman 3 of the said circular being relevant is reproduced herein under 137. Taking into account the specific stand which have been taken in the circular of the Department of Telecommunication, Government of India, this court, by the detailed order dated 12/3/2024, included the Union of India as a party to the instant proceeding, as respondent number 12 to the instant proceeding, and directed the said and directed the respondent number 12 to apprise this court on the basis of the materials on record as to whether there has been any violation by the respondent number 10 and 11 to its instructions dated 1/8/2016 in respect to the present case by filing an affidavit. In that regard, an affidavit in opposition was filed by the Assistant Director General Compliance, Assam LSA, Department of Telecommunications, Ministry of Communications, whereby a detailed report have been given as regards whether the respondent number 10 and 11 have duly complied to the circular of the year 2016. In paragraph number 3 of the said affidavit, it was stated that as regards to clause 3 of the circular of the year 2016, there was overall there was non-compliance to the said clause. In addition to that, in the said affidavit in opposition, there is a circular also enclosed as regards for alternate digital digital KYC process for issuing new mobile connections to subscribers. Taking into account the above, this court heard the matter on 22/5/2024. And in view of the various contentions raised pertaining to the investigations so carried out by the Rongya, by the investigation officer of the Rongya PS case number 944/2020. And furthermore, certain intricate details, to understand certain intricate details pertaining to internet banking and mobile banking, this court sought the presence of the investigating officer of the Rongya police station. In addition to that, this court had also today, the investigating officer of the Rongya police station is present. He apprised the court that the charge sheet has already been submitted. However, leave has been taken from the court for submitting a supplementary charge sheet. During the course of the hearing, this court inquired with the investigating officer as to what transpired from the case diary. The investigating officer submitted that during the investigation, it came to light that the accused persons, taking the benefit that the petitioner is a senior citizen, how managed to get the ATM details as well as the ATM PIN. Thereupon, the accused persons went to a CSP and then CSP of a bank, and CSP means customer service support of a bank, and obtained the mobile number in respect to the account of the petitioner. It also came to the light during investigation that these accused persons called up the petitioner and inquired in whose name the account number and had called up the petitioner and informing him that certain amount is to be deposited in his account, had sought for the name of the petition of the name in whose the name of the and sought for the name of the person whose mobile number the petitioner had put in his bank account. On getting that information, thereupon, the accused persons obtained the fake ID, election commission, fake ECI ID of the name of the same name of the petitioner's daughter, and thereupon applied and thereupon could manage to get a fresh SIM, the SIM swapped. It also came to light during investigation that the said amounts were withdrawn in the name of some applications through a dark net facility, DARKNET, dark net facility. And thereupon, an amount of 20% of the said amount have been retained by another accused who is yet to be apprehended, and the remaining amount have been transferred to the accused persons who have in the meantime already transferred the said amount to some other accounts which could not be traced. He further submitted that under such process, the charge sheet has been submitted, but there is a requirement for further investigation. Today, during the course of the hearing, the chief manager of the Rongia branch of the SBI was also present, wherein he explained as to how the internet banking facility could be availed without a branch visit. He further submitted that there was no fault on the part of the bank which resulted in the fraudulent transactions. And in fact, it was the fault on the bank of this, on the part of the State Bank of India, on the part of the Airtel authorities for permitting the SIM swapping without proper verification. The learned counsel appearing on behalf of the State Bank of India further submitted that the petitioner had also compromised certain details. Else, the ATM details, the debit card details, as well as the PIN number could not have been obtained by the respondent, petitioner. It is under such circumstances the learned counsel appearing on behalf of the State Bank of India submitted that there was no fault on the part of the petitioner, part of the State Bank of India, and there has been, and as the petitioner had compromised his position, compromised the details, it is on account of that the petitioner has to be also blamed for the loss suffered by the petitioner. I've also heard Mr. D. Das, the learned senior advocate, appearing on behalf of the respondent number 10 and 11, who placed reliance on an additional affidavit which was filed on 27/5/2024, which stipulates as to how, wherein it has been stated as to how, pursuant to a notice under section 91, the officials of the respondent number 10 have duly replied. However, there is no mention in the said additional affidavit that there is any rules of procedure already established or set out on the basis of which it is mandatory on the part of the Airtel authority to issue a notice, issue a short message, SMS service, to issue a message to the subscriber when an application is filed for SIM swapping. There is also no mention in the said additional affidavit. Mr. Borua, your name I put it without your presence. Anyways, you think about what if there is a fault of your circular. If there is your circular has been violated by Airtel authorities, which is there, what actions does DOT do? I'll give you. Whether the DOT cancels their license or imposes a heavy fine upon them. Because normally, when DOT takes up the matter, the fine is much higher. Allah, it is in crores. So, what do you do? We'll take it up. I'll be directing you to get that instrument. Yes, others may go, no matters can happen today. Do that. Any stated rules of procedure, what is required to be done, it is also not mentioned in the additional affidavit as to what is the protocol followed in the circumstance the message is not delivered. Or the delivery status is failed. The above issues which have cropped up in the instant proceedings would require further deliberation. Inasmuch as it is a very important, it's a very, it is a present, it is a very pertinent issue in the day-to-day life of the citizens of this country who have bank accounts and also provide their mobile details. What safeguards that DOT authorities would be taking against the infraction to their guidelines? Whether the state bank, the bank would be solely responsible if there is also a contributory fault on the part of the mobile licensee. Which led to the illegal and fraudulent transactions happen. This court have also perused the charge sheet and the state charge sheet, in the opinion of this court, is not to the mark, taking into account and taking obviously into account that these cybercrime activities requires technical personnel, the assistance of technical personnel who knows the know-how as to how these cybercrimes are committed. Therefore, in the opinion of this court, the prima facie, the Rongia police station, case number 944/2020, have to be further investigated upon. And more so, taking into account what was stated by the investigating officer during the course of the hearing. Accordingly, this court directs cybercrime. Who is there? Who is the authority? SP? SP. The superintendent of police, cybercrime authority, cybercrime what? SP, therefore directs the superintendent of police, senior superintendent of police, special superintendent of police, CID branch, CID branch, cybercrime. CID cybercrime to take up the further investigation in respect of Rongia police station case number 944/2020 and to submit a report before this court on 18th of July 2024. A copy of the instant order be furnished to Ms. Yuda, the learned additional senior government advocate, to take appropriate steps in that regard by the raised. This court have also taken note of in the previous segments of the instant order, this court have taken note of the circular dated 6/7/2017 of the Reserve Bank of India, and more particularly to clauses 6, 7, and 8. The counsel appearing on behalf of the petitioner submits that this is a case falling within the ambit of clause 7, Roman 2. Whereas the counsel appearing on behalf of the State Bank of India submits that this is a case falling under clause 7(1). A perusal of both the clauses, clause 7(1) and 7(2) show that in the case where loss is due to the negligence of the customer, such as where he shared the payment credentials, the customer will bear the entire loss until he reports the unauthorized transaction to the bank. And any loss occurring after reporting of the unauthorized transaction shall be borne by the bank. However, in the case of in the circumstances falling under clause 7, Roman 2, where the responsibility for the unauthorized electronic banking transaction lies neither with the bank nor with the customer, but lies elsewhere in the system, and where there is a delay of 4 to 7 days after receiving the communication from the bank on the part of the customer to notifying the bank of such a transaction, the part transaction liability of the customer shall be limited to the transaction value or the amount mentioned in table 1. It is also seen in clause 8. In the instant case, taking into account that it is a saving bank account, as per table 1, the liability would be 10,000. Or the transactional value, whichever is lower. This court further peruses clause 8. That clause 8 also takes note of clause 8, which stipulates as in respect of overall liability of a customer in third-party breaches, as detailed in paragraph Roman 2, clause Roman 2 and clause Roman 3, where the deficiency lies neither with the bank nor with the customer, but else lies elsewhere in the system, it would be in terms with table 2. In terms with table 2, if the reporting is done within 4 to 7 days, it shall be either the transactional value or the amount mentioned in the table 1, whichever is lower. In the instant case, a perusal of the materials on record would clearly show that the petitioner herein that I know 5 days. What? Find you also informed out there. See your complaint, your reply. Anyway, you must have got the FIR because you have replied out there. Anything more, Mr. Kedas, you say, the same amount should be imposed as cost upon you. So, that perusal of the materials and after hearing the parties, it transpires the petitioner herein had duly informed the respondent authority, the respondent State Bank of India on 9/10/2020. And this aspect of the matter is apparent from a perusal of Annexation 9 to the petition, which is a due acknowledgement by the Chief Manager, Rongya Branch. Under such circumstances, the reporting was done within the period of 4 to 7 days. In the instant case, the petitioner have not shared the payment credentials. As will be apparent from the investigation which have been carried out, it may be a case where the petitioners, the fraudster, may have fraudulently obtained the debit card details as well as the PIN number. But the burden in terms with clause 12 lies upon the State Bank of India to prove that there was a negligence on the part of the petitioner. Which is apparently lacking. Under such circumstances, in the opinion of this court, as the transaction in question what had happened on account of third party interference, third party breaches, which even includes the respondent number 10 and 11. Which even includes the complacencies of the respondent number 10 and 11. In the opinion of this court, taking into account clause 7, Roman 2 and 8, the petitioner is entitled to the amount of rupees, is entitled to the amount which were fraudulently transacted through internet banking as well as by UPI transaction, including the ATM withdrawal made through Cash. After deducting the amount in terms with table 1, this court therefore directs the respondent number 9. Huh? Which respondent? Chief, State Bank of India is what? The respondent number 6 to 9 to reimburse, to credit an amount, the amount after making necessary deduction in terms with rule, in terms with table 1, to the account of the petitioner. Within 10 days from the date, a certified copy of the order is served upon the chief manager of the Rongia branch. This court directs the said payment to be made as an interim measure in order to take care of the situation, in order to yes, which word? In order to what?
Financial transfer.
No, no,
on his
that is not. In order
a
to
retired person or died over the
I'll put the word. Resolve the miseries the petitioner had to undergo on account of the fraudulent transactions which occurred to his bank account. That too, a person, that too, a senior citizen whose entire pensionary benefits have been taken away by such illegal means. This court, however, keeps the matter pending in order to adjudicate as to whether the petitioner hearing, the State Bank of India hearing, would be in a position to adjudicate as to how, as to whether the as to what further course of action can be taken, so that the State Bank of India who is also not at fault can be recompensated, taking into account that there appears to be some there appears to be prima facie fault on the part of the respondent number 10 and 11. This aspect would require a further adjudication, further detailed adjudication, for which this court also would request would direct the respondent number 12 to apprise this court on the next date as to what steps are taken against those licensees who, by the Department of Telecommunication, who violates the circular. List again on switch. They will come up, don't worry. Once a cyber crime comes in, that is what. Mr. Das, his affidavit, what he is going to file, he can't bring all those things because his charge sheet doesn't say anything to the charge sheet says, these are the people I found good crime. No, therefore, this is why the cybercrime needs to take in. No, it has to be done because you have, in fact, the central government also has a CBIC, Cyber Bureau of something, CBIC. They also do it, central government. They deal also with these things. Because here it may not be possible on their part alone to do it, the cybercrime. Taking into account if there is somebody from Bangalore who is doing it, then you have to involve the CBI. It is how.
My lord.
Yes, your matter.
Item number 14, my lord.
Yes, what is the matter?
Matter that they want to edit some additional evidence. That
Then?
was rejected by the first appellate court.
Yeah.
Then here it was stayed and it was dismissed for default at this stage of admission hearing. Now it has coming up on hearing column. Therefore, that it's getting delayed and the process is stalled. Final lordship at admission column.
We'll take it up at 2 tomorrow. Tomorrow? 2?
At
2 o'clock? So item number 14 for admission, na?
It is for admission, but now it is coming for hearing.
Item number 14 wrong. The matter has been wrongly listed. We listed again by tomorrow. There's a stay.
Stay is not restored.
There's a stay.
Restored.
Stay is there.
Stay was there. It was vacated, but while restoration petition was filed, that court did not grant the stay effect.
But automatically comes in, na? So this the matter tomorrow at Okay.
My lord, the item number 17.
Obliged lordship.
At 2, my lord. Item number 17, my lord. Argument was concluded because he was just going to pass the order. May it come upon last day, my lord.
What item number 7?
My lord, it was TRT matter, whether Eviction Act Section 5 is applicable or not. It was.
Oh, that matter.
Yes. May it be on 30th, my lord, the 30th.
Huh?
If your lordship has no. Argument was concluded, my lord, only your lordship.
You are take it a look.
Yes.
And who is for Mr. R.T.?
Mr. Bonik argued on that day. Mr. Bonik argued on that day.
Now you see that judgment. State of Maharashtra versus Borse Industry.
I thought.
See that judgment because there is you will get the answer to what is your problem.
My lord, kindly which one, my
State of Maharashtra versus Borse Industry, BORSE. Because here what has happened, initially 34, you had 120 days, 90 plus 30. Then when the appeal were filed, the Supreme Court opined out there by a division bench that the limitation which is given out there in 34 shall also apply in the same tandem in 37. Then the matter went to a 3 judges bench and held that here the proper limitation would apply as if like a first appeal or whatever may be. Here you will get the answer because there it does not mention anything about that. Section 37 does not say anything to that. But then the Supreme Court applying 29(2) did it. This will be your answer. Irrespective of what the Supreme Court, the matter is pending. Nah? So
Yes,
let it be.
but
It's a different thing.
my lord, one judgment we have got that in 3 latest judgment, 2022 judgment, the Supreme Court is saying that in this situation, a category of situation, 227 under 227 your lordship can interfere. One among them is a decision based on inferences that are impermissible in law.
Oh, but you have that problem now. Why should this court under 227 do it? That answer you have to give me. This court would not. If it is a 226, this court would have done it.
Yes.
But how can this court decide on 227 as regards a legality? As regards a legal question, can this court do it? When there is an appeal provision is there. You see, 226 you can. When a question of law arises, then you need not be God. There are many judgments to the effect. But 227 can this court. For what? No hearing, no hearing. All this hearing after vacation.
My lord, when it will come, my lord.
So what? Top of the list I have picked. I have put it down the list. What? Fix? No fix. No. You see, Mr. Counsel, the kindly see one thing. What is that top of the list? Understood. But the thing is that you see, I'm not sitting from third. And then I can't impose upon my fellow friends, fellow judges to do so. So for them, and I don't know whether after coming back I'll do it or not. Thursday, you have seen the list, so long list back.
My lord, my one is not fixed for us, my lord.
Okay, that's a part of matter. Na?
Yes.
We'll have it after vacation. Okay, let us have it after vacation.
Maybe continue, my
23rd of July in time. Which one part 1? I've not heard you. No.